like to introduce our speakers for today. Joe Dreitler is a 30-year veteran in IP field. He's worked with different prestigious companies, including Procter & Gamble and Anheuser-Busch. And just yesterday, a client of his told me that Joe certainly loves what he does. So I'll share later. And Mary True has over 20 years experience as an expert in the IP field also. Her past clients include Britney Spears, OSU, and Kate Spade. Ms. True and Mr. Dreitler are currently partners in their own firm in downtown Columbus. Welcome, Mary and Joe.
Thanks, Marla. Marla said this was going to be interactive, so I'm going to hold her to that. And I hope that as you have questions or things that don't make sense because I haven't said them correctly or Mary hasn't, you'll ask them. There are no dumb questions. Just so we get a little idea, how many of you people handle or are involved in trademarks as part of your job? Okay, we got 3. Okay. Law firms or in-house? Law firm? Law firm. Law firm. In-house. Okay, there you go. Okay, so of those who didn't raise their hands, how many have any basic knowledge of trademark or copyright law? Okay, all right, good. Marla was kind saying 30 years, but 1978 seems like it was a short time ago, but who's counting, right? My experience over that time in being in this field is that it takes about 3 to 5 years for somebody working day in and day out with trademark law. It doesn't matter whether they're a lawyer or paralegal, to have a good understanding of it, to be able to not only spot issues, but to be able to do what is required in a particular situation. And it's funny when somebody comes and I'm training them or wants to talk to me about what I think they should do if they're interested in the field. The first thing I say is to read McCarthy cover to cover. How many of you have read McCarthy cover to cover? Nobody. So you've got some learning to do. The last person that I was involved in training did that. She came back to me after about 3 months and doing it and said, she said, I read it, I said, and she said 6 volumes, that's a lot. And I said, yeah, I said, I'd say you should read it 2 or 3 times. I said, of course, when I started, there were only 2 volumes to McCarthy. That's a true story. So that just says, what it says is that a lot has changed in this area. We'll try to hit some highlights today. We'll go for like an hour and then take a break. But as far as you can't cover everything. Clearly, online internet hasn't changed the substantive law, although a lot of people would like to think it has, but it certainly has brought other things into play when you're practicing trademark law. I guess everybody's familiar with this. This is the definition that appears in the Lanham Act. The Lanham Act is the federal trademark law. 1946, named after Congressman Fritz Lanham of Texas, who was the sponsor of the bill. It's fairly broad, as you can see, as far as what it is, a word, name, symbol, or device. It's something that identifies and distinguishes your products or services from somebody else. That's the whole purpose of a trademark. That's what a trademark is. That's what a trademark does. Ohio has its own statute, by the way. Are most of you, the people that are familiar with it, do you practice federal or state? Do you use the federal law or the state? Both? Okay. The definitions are the same as far as that, because OSBA was involved in revising the definitions a few years ago when the Ohio law was updated. We'll talk about that in a bit, and hopefully you'll have some questions about the differences. As you can see from that definition before, there are a lot of things that can function as a trademark. It's a symbol, it's a logo, it's a slogan, it can be a package, a lot of package designs, but basically the point is it's something that identifies and distinguishes your products and your clients' goods from others in the marketplace. A service mark is pretty much what it sounds like. It's a specifically defined term, same as a trademark, but it's used in the basically the offering of services, and it's pretty obvious to think about that: grocery stores, airlines, retail stores. And so it's not uncommon to find a business, for example, a retail store that has a service mark for their stores, think of Macy's, and yet is also using that as a trademark for their goods, think of Macy's, private label Macy's type of products. There are a couple of other beasts called collective marks and certification marks. Collective mark is just what it sounds like. It indicates membership in a group or an association, and people who are members of that group can use it. It's protected just like a trademark. An example of a collective mark would be like the AFL-CIO for use by union members. A certification mark is somewhat similar. It basically is a company registers a certification mark, and anybody that meets their standards can use that. For example, we've all heard of the Good Housekeeping Seal of Approval. That's a certification mark. If you meet certain standards, Good Housekeeping allows you to put the Good Housekeeping Seal of Approval on it. Protected, registered, the same way as a trademark or as a service mark.
We usually think of the way we encounter trademarks mostly or something like a brand name on something. But there's certainly a sound mark that, if any of you watch football, you've probably been hearing an awful lot of commercials with a certain quarterback singing all kinds of funny little tunes to the Nationwide. The Nationwide is on your side. That little ditty is also a federally registered trademark. So just all these things that are used to, and when you hear that, you think of Nationwide, and that's why it is functioning as a trademark. So there are a lot of different ways that that companies get in there and get you to identify and recognize their products.
That's a good point. And the other thing, and I think we'll touch about it, is that some things can be two different types of intellectual property. Mary just mentioned the Nationwide is on your side. Those specific notes are a trademark. Of course, that song is also copyrighted. That makes sense, everybody? Protected under copyright law, and it's also protected as a trademark. So, in other words, nobody could use the song and make a recording of the song without their approval of the copyright, but it's also protected for insurance services. So, it's a dual threat. Trade names, corporate names. Trade names are not protected under federal law. There's nothing under federal law that even talks about it other than you can't register a trademark if it is the same or similar to a previously used trade name. But a trade name does not give you or your client any protection. They're used to identify the business of the user. And for example, in my case, as Marla mentioned, I was the Chief Trademark Counsel at Procter & Gamble for a number of years. Procter & Gamble was a trade name of Procter & Gamble for the corporation, which is the Procter & Gamble company. And again, compare this to a trademark, which identifies, again, a product or a service, while a trade name simply identifies the business. And for those of you who don't know and don't practice in this area, I guess I would say that if you take nothing away from whatever else I say, please don't ever think that by registering a trade name or a corporate name with the Ohio Secretary of State that you have protected your client. You haven't. You've set yourself up to be sued for malpractice if a trademark owner sues them for infringement. I think we have had, in my experience of 37, 38 years and working with Mary for the last 16, too many people who have called us up and they set up a corporation or they had a law firm, small law firm, set up their corporation and they filed a trade name and they got a trade name certificate, and 6 months later they got a cease and desist letter from somebody saying stop using it or I'm going to sue you. A trade name is simply that. It's used to identify a company or business. and serves as the name of the company. It is not a trademark. It does not give you trademark protection.
It's actually happened twice this week. Kind of having a run on that lately.
You know?
You feel like a real bad guy when you have to tell somebody that. but-
Yeah, and they almost want to cry on the
Trying to
phone.
cry on the phone, yeah.
And they tell us that, you know, they're,
So does that say that a business owner should do his research before he picks his name then?
yes, absolutely. That is the moral of that story, because if you just simply say, well, the Secretary of State's office said it's okay, we've incorporated under that name, and we have a trade name, then you're at that point of going back and then having to change everything, because then if they start their business and use it as a service mark or trademark or both, then they're going to have to go back and change their company name as well. And the trade name certificate isn't worth two things. That's a really good question.
Was that the situation? I think there was what used to be J. Lou's is now something else. Was that the situation with that?
I think it
'Cause
probably.
I heard they had not researched the name, and they were using it
Yes.
locally, and then they had changed the
Right.
restaurant name, they had the name bill,
Right.
and had to change everything with it.
Right. You're absolutely right. There was another company that had a federal registration of that, and whoever incorporated them didn't. And if you, this is kind of simple stuff, but again, in this case, the plaintiff had an Ohio trade name registration of Pizzazz for 10 years, and then decided they were going to sue Taco Bell for using Pizzazz pizza for a menu item. And the U.S. District Court in the Northern District of Ohio held that plaintiff's Ohio trade name registration was not proof that the term functioned as a trademark for him, or that the plaintiff had any exclusive rights to use it. And so an Ohio trade name registration, to beat a dead horse here, doesn't create any exclusive rights. It is, in our view, it's simply a ticking time bomb, and provides your client with a false sense of security that they think they own something unless something happens. It doesn't add any additional benefits to them just going out and using it, which, as we know, without doing a search, and we'll talk about that in a couple minutes, is the most important thing. And it creates no presumption of validity, and you can't stop an infringer with it. So I'm sure that the people that filed that lawsuit against Taco Bell and the lawyers wish they hadn't done it. Again, I'm just going to go back over this every now and again just to make sure, for those of you who haven't done it before, the function of a trademark. There's 3 of them. There's probably another dozen you can come out, but obviously it's a source indicating thing. When you see a swoosh on a shirt, you know what it means. It indicates the source of the goods, and it's intended to tell people that if you buy this product, it is going to have a certain guarantee of quality, and the more it's used, the more well-known it gets, the more famous. It certainly does create a demand for that particular product. To your point about what to do, there's a lot of different ways to talk about how you do trademark searches and brainstorming, and what does brainstorming mean. And you know, I worked at a couple companies that were fairly sophisticated when it came to that. Interestingly, in both of them, their outside advertising agencies would often try to tell them, oh, this name's clear, and then the in-house lawyers would get it, and we'd wind up doing a search and finding out that it wasn't particularly clear. But when a client comes to you, there are a number of ways to do preliminary searches. Some are really cheap, easy, down and dirty. A lot of people go to the USPTO's website. It's worth doing because it doesn't really cost anything other than your time. The downside is it really picks up not much other than something that's identical. It doesn't pick up phonetics if you're doing a preliminary search. A full search is just what it says. There's a couple of vendors that do them, have been around a long time. It turns up federal trademarks, common law trademarks, domain names, business names, common law users around the country, which is what you want to do before you're actually going to adopt something. The problem with full searches is they've gotten really expensive in the last 10 or 15 years. I think part of that is because of the fact that they have added so much stuff. Like I said, they put in domain searches, and then they put in internet searches, and then they put in all sorts of stuff. A lot of it is terribly useful, but the point of it is, if you have a client that comes to you and is coming up with a new name for a product or a service, and you don't do some kind of a search, and you don't qualify that, whether that's preliminary and you say, we're going to do a knockout search, and here's why it's a knockout search. And so you understand that, we recommend a full search, but if you don't do a full search, it's a matter of you're assuming simply more risk, and that's basically what it's about. And you'll always wind up with clients saying to you, well, what should I do? Which is obviously what they want you to do, is make their decisions for them, which is something that you can't, because you're just a lawyer. But you can assess the risk, and that sort of goes back to my original point, which is it takes 3 to 5 years to train a paralegal or a lawyer to become proficient in this area, having seen enough of these things, understanding the law, applying the law to it, and to basically come out with a risk assessment for somebody to say, if you do this, I think the odds are 80% that you're going to be okay, or 70% you're probably going to get sued, or if you get sued, the odds are probably 100% you're going to lose. So it's a pretty important thing. As I said, the problem with them is today they're so big and bulky. They used to be about 20 pages long. Now they're like 300 or 400 pages long. But you can't avoid doing them if somebody's going to spend the time and money and start a new business. And I think that's the problem. A lot of new businesses don't have a lot of capital, and so they sort of try to go cheap on this. And some of them, as Mary said, twice this week, we've had people who did that, and it's going to cost them a heck of a lot more money. Yes, Marla?
I just was going to share my experience of how you use the preliminary searches, because in my previous job, we had a new product coming out, and we're looking for a name. I had to run probably close to 75 different names to get 3 that came out of preliminary search that we thought we might be able to use. And so then I told marketing and the group, pick your top choice out of that. We'll run the full search on that and see if we can use that then. So you can keep the cost down by running all those preliminary search, get it to your top choices. Pick one and spend the money on that one. But like you said, make sure you spend the money because it's important.
It's important, and it's embarrassing, and make sure that when you do spend the money on it, there's some realistic, someone looks at it realistically. Again, we're talking about the selection process and searches. The biggest one, there's a whole lot of reasons why, and we'll talk about them, why the Federal Patent and Trademark Office might refuse to register something. The worst, the one that's going to cause you to get sued is that one, likelihood of confusion. It's subjective. Again, it takes time to understand what it is, but there are certain ground rules. Are the marks similar? Are the goods similar? Is the marketing channels the same? Are the target customers the same? Are the purchasers sophisticated? Over to the right, there's a Current Communications. There's a company, they're no longer in business. Current TV, 10 years ago, we were involved in a company called Current TV that was started by Al Gore. And they got sued in Cincinnati by a company called Current Communications that was doing, which never took off, broadband over power lines, meaning you plugged into your wall socket and you got broadband. They sued Current TV before they launched a television channel, and sued them and asked the federal court in Cincinnati to enjoin them. Current TV had done a search. Doesn't matter at this point. I think they were a bit aggressive, but that's what a client can do, and they decided to go ahead anyway. I would say probably with a little bit of luck, they didn't get enjoined, and we wound up getting a decision in our favor. But the point of it was there are some definite ground rules, and it all depends upon how much risk. And a good search is going to give you about 95%. There's always something that can turn up, because unlike most countries, the United States has common law, and unlike most countries, common law rights are legitimate. And when I say common law rights, that means that if someone's been using a term in Phoenix for 20 years as a trademark, and you're not aware of them, you do a search, you don't see them, and you begin using it, they still have their rights. You can never stop them from using it in the area in which they are. Those are called common law rights. A good search should turn that up. And then you just have to decide, and that's, we're getting way into the weeds here, how to deal with that. And there are ways of dealing with a local common law user. Again, you find out, are they that close, are they similar, whatever, but you sure as heck don't ever want to have a client go forward if you turn up something even on a common law portion of a search that's similar, and just sort of blow it off and ignore it. Make sense?
Yeah, the idea that it's very fact specific whether there's a likelihood of confusion. I mean, if you think of Delta Airlines, Delta faucets, I mean, obviously the marks are identical, but nobody's confused because they're being used on two totally different things. So you can't just look at a search and say, oh, that mark is being used. You really have to see and how is it being used. And most times it isn't quite that clear where you have such completely different areas. But there are a lot of things that have to be balanced and weighed to determine whether your position is defensible, whether there isn't going to be a likelihood of confusion, and basically, while the trademark office might register it, that doesn't necessarily mean that somebody isn't going to sue you for trademark infringement later on, and we'll certainly get to that. So, but there's a lot of different facts you have to keep in mind.
Right. And as part of that, this is sort of just a nutshell of that in clearing a trademark. In other words, in giving a client an opinion that says, we've done a search, we've done whatever, and here's our assessment, and we're applying the law that's used to determine likelihood of confusion or whatever you do. A full search is going to have a federal search. It's going to have all 50 states, state registers. The problem with those things is that they don't usually update them but once a year, so state searches are good for what they are, but that's that 5% that you may not come across. Common law, business names, you get that, you get internet. Again, as Mary was saying, you find somebody out there that's kind of similar, you wind up hiring private investigators. I've had the misfortune of having to do programs about what you can do and what you can't do. One of the things that you always wind up saying is, don't have your lawyers and paralegals calling up and misrepresenting themselves. You can get yourself into a lot of trouble if it turns out that you get involved in a piece of litigation. And I know that that's happened on many, many occasions, and there's a lot of case law on that. If you're going to do that, hire a private investigator to do it. You probably don't want to have somebody in your office do it who's going to wind up being a witness. If your client goes ahead and then they wind up getting sued, and then it's like, well, how did you find out about us? And it's like, well, we did this, and Joe Schmo or whatever called up and didn't think you were using it. Ultimately, a lot of times you can negotiate to buy rights. Big companies do that. If they find somebody in Texas using something, when I was at Anheuser-Busch and we were coming up with craft beers, it wasn't, people wouldn't mind writing a check for $750,000 to buy somebody's rights off somewhere. That can happen. Cancel if abandoned. Trademark rights in the U.S. are based upon use. I'm not sure we're going to get into the weeds much on abandonment or not, but use. We are a use-based country. And so if you register a trademark today and it's being used, and you use it for the next 6 years, and you decide your client decides, they're going to change the name or do something else, and that registration is still sitting on there, it can be canceled. It's not, after 3 years, it's not worth the paper it's printed on. And our law is such that you are not supposed to renew them, because if you renew them and they're not in use, they're subject to abandonment, and you basically have committed fraud on the Patent and Trademark Office by saying or swearing that in fact it was in use. So there is a lot of stuff out there, which is another reason that when you do a search, you will find lists of registrations that doesn't say that they're canceled or anything, but you wind up going online to try to find the product or having an investigator do it. You can't find it because it's abandoned, and yet it's still sitting out there. And so a lot of times, I think that certain studies that I've seen by different people, as much as a quarter of the federally registered trademarks that are still active are actually dead. No one's told them they're dead. They're just dead.
Because it doesn't really matter unless somebody else wants to use it. I mean, the mark will eventually expire.
Right. You have to renew them every 10 years.
So, but again, if something turns up on a search and it says it's a live mark, This is the sort of thing you investigate, is it really?
Right, that's not the end of it. I mean, the easiest thing someone told me when I began is to tell a client, and I think it applies to trademarks and anything else, is to tell a client, no, you can't do that. It's really easy to do that. Because you know what? If you tell them that and they don't do it, nobody can ever come back and say you gave me bad advice. The hard part is trying to figure out a way, which is why you have to understand your area of the law and do your investigation, is to tell them, look, I think you can do it. It's your risk, and here's why I think you can do it, and it's defensible to do it. But I knew people, and I've worked with people, unfortunately, that, you know, anything that was close, they just say, blocked, blocked, blocked. And the client would get frustrated, but what are they going to do? You know, they don't know as much as the lawyer or the paralegal. So that's the hard part, which is to make the call and say, look, I think we can get you where you want to go, but here are the things that you're going to have to do to get you there. Trademark registration, this is federal, not state. State is about $125, I think, or $130, something like that. And we'll talk about why you get what you don't pay for. Most people file them online now. Application, drawing the mark, specimen showing the use. Usually now today it's a JPEG showing it, you know, like on a tag on a shirt or a sign on the front of the store. It's been a long time now. It's been since 1989 that in the U.S., again, remember we talked about use. Use is key. Used to be that the only way you could file a trademark application was if your client was actually commercially selling it. The problem with that is nobody wanted to take the risk and start a business and not have a trademark application, so people would make what was called token use. They'd ship a couple things across state lines and claim that as their date of first use and file applications. So to get around with that, in 1989 the law was changed, and so you can file it if it's legitimate commercial use or what's called intent to use, which means your client has a bona fide intent to use it. You file them either way, but on the second part, which is intent to use, your client doesn't get a registration. It goes through the same process, but they won't get the registration until you submit a sworn declaration stating that it's been in use, when it began in use, and a specimen showing it. So
The point of that being that when you file intent to use, the date that you file the application is your priority date once the thing finally registers, and nobody can get in there ahead of you. It's an insurance policy for sure.
That's right. It's the priority date. In other words, the date you file an intent to use trademark application, which is January 20th of 2016, if your client ultimately begins use and gets a registration 10 months from now, anyone who adopted it tomorrow is subsequent to you, and you have prior rights. Your rights are superior to theirs. That's the whole point of intent to use, and encouraging people to file it, have priority. It cuts off anybody else from adopting it anywhere in good faith if you get the registration. So you file it, it gets processed, it's assigned to an examiner, you get a serial number. Probably 3 to 4 months later you'll hear something back. Usually there's an office action is what they're called. They're refusals from a trademark examiner who has it. A lot of them are technical. Most frequent ones are, and we'll talk about this in a bit, substantive ones are basically that either it's likely to cause confusion with a previously registered mark. Remember, if you do a good search, you ought to be able to know that. Or that it's merely descriptive under the Lanham Act. And you've got 6 months to respond in order to try to overcome that. And if you do, then it goes on, gets passed on to publication, and we'll talk about that in a second. Again, what's the purpose, as we talked about? A federal registration, unlike a state registration, cuts off subsequent users from for adopting the same term in good faith on similar products. So if your client, and this is again the issue that we had twice this week, if there's a federal registration by somebody in Arizona or California or whatever, and your client begins operating a similar business today under the same name in Ohio, and you get that letter, you lose. Federal registration cuts off anybody from adopting same or similar term for similar goods in good faith and saying, I didn't know. You are presumed to know by the fact that it's registered. Yes, ma'am?
I mean, how does that work? I mean, you always are gonna have some things that are, like, just for instance, like Joe's Pizza or something.
Right.
There might be a Joe's Pizza, like, in every town in the country.
Correct.
So how does that work? So they just, none of them are registered, or?
Probably they're not registered. Probably if you had a client come in and say, do a search at Joe's Pizza, you'd wind up, there may be a federal registration of it that's 60 years old for somebody in Brooklyn or something, but that common law portion of the search is going to show just what you said, probably 50 or 60 common law uses of Joe's Pizza. If the guy in Brooklyn who registered it was before any of those other people, theoretically, he could go after them and make them shut them down.
Okay.
If he registered it and they were before him, he doesn't cut off their rights. Your common law rights are there. So if Joe's Pizza has been operating in, again, Orlando, and I don't know about it, I file a trademark application and I register Joe's Pizza today, and there's a Joe's Pizza in Orlando that's been operating 3 pizzas in Orlando for the last 10 years. That registration doesn't give me any ability to go down and stop him from operating in Orlando. What it does do, if I didn't know about it, is it blocks him into where he was. He can't expand outside of his geographic area where he has common law rights. Makes sense?
There's actually a Tiffany's jewelry store in Springfield, Ohio. I doubt if they use blue boxes and stuff like that, but it is there, and Tiffany knows about them, but they can't do anything about them. But they'll only be in Springfield, Ohio.
Forever and ever and ever.
I saw that in Florida too. There was a Waffle House that is not a Waffle House.
Is that right?
So when you look at it, you know it's common use.
Right. Yeah, this sort of thing happens frequently, like in restaurants and stuff like that, where, for the most part, if a restaurant's a local business, and, the idea of having national protection, unless you're going to be a franchise, is, not of much value. The internet has changed a lot of that, however, because everybody now thinks they're a national business because they're online.
Right, but there are a lot of common law users.
But common law users of the local restaurants a lot.
So for those of you who are involved, why do you register trademarks? Don't answer that, but why? Why do you say to a client, you should register this trademark?
Protect your interest, I would think.
Okay, that's a good one. And here's where I'm going with that. And a lot of times it depends on who the company is. A trademark registration can be a defensive weapon. Meaning, if I've got that registration and there's nobody else using it, I can expand, excuse me, and nobody else can stop me from expanding. It can be an offensive weapon too. And a lot of companies register because they're offensive weapons. It's not just simply a piece of paper, you stick it in a file and you forget about it. Some companies go, okay, we've got this registration, now let's go out and look for anybody else that's using it and stop them. And that's what you see a lot of times in very competitive industries. So it has 2 purposes. It's offensive and it's defensive as well. And I think one of the things is a lot of times, whether you're a lawyer, whether you're a paralegal or whatever, it helps if your client lets you get some input into what they're trying to accomplish. If all they say is, I want you to register this trademark, and they don't want to hear anything else from you, talking about third parties, what are they going to do? Are they going to try to build this brand nationally? Are they going to try to use this name to basically stop others from getting into that space? And that gets into picking descriptive names, which, again, we could spend a couple hours on names to pick. A lot of clients want descriptive terms. When you get a descriptive term, it has a lot less protection than an arbitrary term like Xerox or Buick or Google. And so it's a lot harder to protect it if it's a descriptive term like Joe's Pizza, where there's a lot of Joe's Pizzas out there. Tiffany's, other than Springfield, Ohio, not so much. It's a pretty strong trademark, and so it's not only a defensive thing to put in a file, it's an offensive thing that you're gonna use to go after people with. Again, just sort of states the federal registration under the Lanham Act. It gives you the right to, exclusive right to use it anywhere in the United States. That's pretty good. So, you know, if you're making use of it, you register it, you have the right to expand your business. That's why people want it. A state registration doesn't give you the right to expand your business beyond Springfield. It just doesn't. It's not presumed valid in a state court or in a federal court. Again, we just talked about the protection. And again, the point is you want to figure out what your client wants to do. Sort of stole my thunder there. Again, state registration is not presumed valid. They don't do much of a search over there. They pretty much let anything go through if you pay the fee at the Secretary of State's office. This is not a shot at them. It's simply that's not their job. And we've had this discussion with them over the years that perhaps the state shouldn't be in the business of doing this because what they do, it's like trade names. Unfortunately, a lot of people get this false sense of security that, oh, I own something now. I've got this. And the answer is they don't. So I guess the question is there any reason why you would want to use a state registration when you can go federal? Anybody think of one? No? Okay. There are two federal registers, as they're called. Basically, you know, you register, the principal register is for strong trademarks to begin with. There's a thing called the supplemental register under the federal system. And we'll talk about reasons why an examiner would refuse an application. But the point of it is, if the term is, if it's likely to cause confusion, it's out. You can't register in the federal system, period. If a term is merely descriptive, meaning, you know, I don't want to say doughy pizza, but some kind of pizza that's descriptive. It's not generic, but it's descriptive. Or if it's geographic, you know, if it's Bexley, you know, waffles. Those are terms which are not initially registrable under the federal system. Yes?
Would that be like Chicago deep dish, is that not?
Chicago deep dish, right. Deep dish is a generic term, and Chicago is a geographically descriptive. Yeah, exactly. That's fine. That would be initially refused. And so we'll get into this in a little bit more depth, but there is a thing called the supplemental register, and it was created with the original act to allow, there were a number of countries years ago that require you to have a registration in your home country before you could file an application in a foreign country. And so this was created. If a term is not registrable on the principal register, and that's what gets the presumption of principal registration, the presumption of validity and exclusive use and right to expand. If it's on the supplemental register, all it does is it's a record. It says it's on the supplemental register and here it's going to sit. It's up to you if you sue anybody to actually show that it functions as a trademark, that you should have exclusive rights to it. But things that are merely descriptive or geographically descriptive can be registered on the supplemental register. And we'll talk about that in a second, which is, I'll give you an example. There was a company years ago, and they're out of business now, but they were owned by R.J. Reynolds. It was a bagel shop called Skolnick's Bagels. And bagels is a generic term, so nobody can own that. Skolnick's was a surname, and so surnames like geographic terms, like descriptive terms, are not initially registrable in the United States. That's the law, only if you develop rights in them through use. And so they hadn't been using it for a year. In order to get on the supplemental register, you have to be using it, legitimately using it for a year. They were starting out. They wanted to call these things Skolnick's. They were opening up a whole bunch of bagel stores in a bunch of different states. And so they weren't eligible to get on the supplemental register. They knew their applications were going to be refused on the principal register. And so they wound up going into like 25 different states and registering them until they had enough use that they could then go back and get a supplemental registration federally and then develop use, which we'll talk about, to get a principal registration. So they can be of some value, but they're not very much for enforcement purposes, that's for sure. Did I lose anybody? No? Okay, good. Again, it's just a rehash process. You do your search, you file your application, intent to use. It goes to the U.S. Patent and Trademark Office. It gets examined by a trademark examining attorney, and then they either object to it and you have grounds to respond. If you are ultimately successful, it gets published in a book called the Official Gazette, and anybody who has an objection, like somebody else that thinks they have prior rights in it, has 30 days in which to oppose it, and assuming that they don't, it's publication. If it's a use-based application, you get your registration. If it's an intent to use application, then you get 6 months in which to begin use, file a statement of use, and get your registration, and that can be extended 5 times, so you get 30 months for intent to use, which is why a lot of people like them, because it gives them time, and in that period of time, nobody else can jump in and grab the name. Yes, ma'am?
What is the timing of all that? Is it about a year? Is it like 2 years? You can tell?
Good question. The application, I mean, again, the way it works today, an application, if your client is responsive to you and sends you a JPEG showing how they're using it on a specimen, tells you their date of first use, tells you what the mark is, tells you the name of their company or whoever it is going to be the owner, you know, it takes about 20 minutes to get an application put together and filed. It'll take about a day and a half. No, it'll take about 6 hours to get a serial number and a filing date back via email from the Patent and Trademark Office. And this has not changed in all the years I've been doing it. The way the Trademark Office is set up, there are different groups that handle different applications in different, because trademarks are filed by class. 25 is clothing, 32 are beverages, et cetera, et cetera. Software is in 9. They're set up, and you have to file for obviously the goods. You have to describe your goods. You know, restaurant services. You know, computer software for use in managing real estate. Different groups within the Trademark Office get applications in their class. And to answer your question, how long does it take before you hear something back from an examiner, depends upon how busy that group is. It can be, sometimes you get them and it's 2 months. Sometimes you get them and it's 8 months. But I'd say the average right now is probably 4 months from filing until you either get an office action, which is a response saying it's refused on this basis, and you can respond. And a lot of times it's really simple stuff. You know, you said computer software, and they want you to say computer software for use in, rental real estate. And so you just say, fine, I agree, and that's how you amend the goods to be, and then it gets approved by them, then it gets published in the Official Gazette. So that's probably examined, let's say in the best timing, it gets examined, they look at it, looks good. 3 months, you get then what's called basically notice of publication that says it's going to be published in 2 months. It gets published in 2 months, 30 days, nobody opposes it. At that point, you basically are told the registration is going to issue in 10 weeks. So on that, if nothing happens and it's a use-based application, you ought to be able to get it done in less than a year.
That's if it sails through.
If it sails through.
There are problems, and probably one of the more frustrating things is if, as we talked about intent to use applications, if there is a prior filed intent to use application, that the examiner says, well, we're going to have to see what happens with this one. There might be some confusion, so then you have to wait until this person either decides to make use or not. And, I don't know what the percentages are of the number of intent to use applications that people finally go ahead and decide to make use on. But it can hang you up for a while, and there's not much you can do about it.
Yeah, it does happen. It does happen. And again, that goes back to why you do a good search, because that should show up in your search.
Right.
It should show up that there's already a published and approved application for Smitty's Barbecue, and you should have done your investigation before you told your client, look, we've done investigations, Smitty's Barbecue doesn't exist. Somebody filed this thing 3 years ago, and it's hung around out there, and it doesn't exist. Or you should tell them, we think there's enough that we can argue that's, if we get an objection on Smitty's barbecue, we can argue that Smith's barbecue isn't likely to cause confusion because there's a whole lot of people using Smith for restaurant services, or whatever your arguments are going to be. But that's a good point. Certainly, it's a good point. That again, yes.
Make your comment.
No, I was just going to say the point is that, again, the trademark office, this is the other thing, they don't look at common law users. They only look, when they do a search, when you file an application, they look at what's registered or applied for before you. And so if there's a common law user out there, you're not going to get a refusal from them on that. You may get a registration and then get a letter from somebody who's a common law user. But the trademark office, when they issue a refusal, it is only going to be on the basis of something that is an active registration or a prior filed application to your client's application. So, your question.
Yes, thank you. Do you have like a range of, like, just a generic, if it sails through, like it costs $1,000 to this, or it costs $10,000 to this? I know it's kind of like throwing a dartboard, but, if somebody wanted to do something like this, and they say, oh yeah, it costs about this much, but you gotta go talk to the person, for a referral or something.
Sure. No, we get that question all the time, and to say it all depends is a cop out. It all depends if you want to do a full search. If you want to do a full search, I'm going to tell you it's going to cost you $750 for us to buy it. We don't mark them up; we just pass them through. If you want me to just look at it and go through the whole thing, and then follow stuff up online, or have our paralegal do that, it's going to at least take an hour of my time to do it with that. If you want a legal opinion to go with that, because you want a legal opinion in your file, that's going to be another hour. Now that's just to do your search. To file it, again, you saw the filing fee, it's $275. And if you've done a really good search, you shouldn't be getting an office action, substantive office action, that's going to block you. And so what you should get back at most, bless you, is something along the lines of what I said, which is the goods description needs to be tweaked. You need to call it this instead of that. And that's 15 minutes of, at most of our legal assistant's time, talking to us, looking it up, making sure it's okay, confirming with the client. So the point is, if you don't do a search and you just do a knockout search, there's a lot more uncertainty. But if you do a decent search and you know what you're doing, the actual process of filing a trademark application and getting it registered based upon use, here's why I say based upon use, because as you saw, it's $275 is the filing fee. Most people are going to charge you $300 or $400 to file it. So you're looking at probably $700 to get it filed. That ought to be it, unless you are so close and your client wants to take a risk that they're going to get opposed. You ought to not have a whole lot of other problems coming down the line on that thing. But if you don't do a search and you just file it, you could have all sorts of stuff and you'll be refused. Worst thing that I think, or we think, is to just have a client that says, I don't want to do a search, I just want to file it. Because my response to that is, I don't like to waste my time and I don't like to waste your money. I want to know before I file this thing what it is that's going to happen to it. That's the whole point. I don't just want to file these for the sake of sending you a bill and say I filed a trademark application. I want you to get something at the end of it. So anyway, that's kind of how that goes. Does that answer your question, or?
Yeah, that's very thorough. I just wanted like a little.
Okay.
Well, you either pay it up front or you pay it along the way. I guess is how it works.
You either do your homework or you're
Yeah.
going to get hit.
Right, and then
That's right.
if you get hit, you end up.
You want to pay $10,000, you want to pay $1,000.
Yeah, it's not real common that it takes $10,000 to get a trademark registered.
No. Yes.
So my question is, so you do a search, you
Yes.
do all your searches yourself, you do all these preliminary, and then when you do the full search, that's a third party that you pay.
That's right.
They do I've seen those.
Right.
Okay.
Thompson and Corsair. You just buy them.
Yeah, okay.
You know, they charge you, like I said, the prices of those things have gone up through the roof. They're $750 now just to buy them.
And I would assume that you would, I'm sorry, make the decision to do the full search and pay that fee based upon that client, how much you think that client wants to secure that name?
Well,
You know, if they sell
sure.
across the United States or something like that.
Right. But the point is, if you want a federal registration and all you want to do is a preliminary knockout search, you know, we can have our paralegal going online and doing some stuff. And that's fine. But it's not, don't rely on it. And if we file something and it gets refused, you know, that's on you. That's not on us. So you're right. You know, TNT and Core Search are the main vendors that do it. And they've gotten really expensive because they put so much stuff in it. I think a lot of it's unnecessary. It wastes a lot of time of paralegals and lawyers having to look at these things. You know, I mean, domain names are a joke at this point. You know, I mean, they can 50 pages of domain names that are somewhat similar, and you can look at them, and a lot of them are still with a shovel saying under construction. It's just a lot of wasted effort. But the point is, the federal search, the common law search, the Dun & Bradstreet search, those are the meat of what you're going to get. If you find something in there, that's where you're going to find your issues or your problems on. And the point is, these searches are probably, like I said, about 95% accurate. I mean, our recommendation to somebody is, if it's important enough that you want to spend the time and money to have us file a trademark application, then it's probably worth doing a federal search. Now, you can flip that around and say, well, when you do it, it's blocked. Then when you say, it's probably worth having our legal assistant spend an hour doing something preliminary, and then if it looks good, then go, look, we've done this, it looks good, but now you got to do the federal. 9 times out of 10, when you do that, you're okay.
Yeah.
The federal is not going to knock you
The
out.
comprehensive, yeah.
If you've done Google searching and looking at the PTO's website, 1 out of 10, something won't turn up that'll only turn up in a full search. You know, that's why you do a full search, to avoid getting sued. But back to the lady's point, $10,000 is, I mean,
No.
that's
You've already gotten sued if you're
you've
spending
been,
that.
you've been sued if you've done that, or you're in opposition if you do that.
Yeah,
So
it's, that's not for registering. I mean, it shouldn't cost more than $1,500, and that's a lot to get a trademark registered.
now, the other part, so I don't forget it, is that's a use-based application. Intent to use, the government gets their filing fee. So if you have a client, they haven't begun use, they file the application, it goes through the examination process, it gets approved, no one opposes it. Now you get what's called a notice of allowance, which says, okay, you got 6 months to begin use. Once you begin use, you have to file, because at some point you have to swear the government, to the PTO, that you're making commercial use and attach a specimen. And that's $150 to do that. That's just the way it is. Now, you can get 5 extensions, and those are $100 each. So you can spend more money
But
getting extensions until you file your statement of use. If you do it intent to use, it's more expensive. So we always say to people, look, if you're about ready to start, I know there's a little bit of risk that somebody could jump in and file an application ahead of you. But if you're telling me you're not going to do it for 3 months or 6 months, then file the intent to use. And as soon as you begin using, we file the statement of use. So we're not spending money getting extensions of time for the next 30 months and then ultimately having to file it. Good questions, yes.
Good question. Another question, but I would say on that, even if you only had one location, like the restaurant I was talking in Worthington, if you compare the cost of having to replace all their signage, their menus, the napkin, everything they'd have to replace, it'd be much more expensive than getting your report and checking that all up front.
Agree.
But sort of question, I don't know if you want to deal with it later down the road, but when you have a situation, as I did in a former job, when you have a company where they're in the US and their counsel tells them they should protect the name in, so we're going to go to Canada, and but then the company says, no, we are going to do a filing there. There's a little local company using in a small geographic area, but we're not going to use this maybe for 5 or 10 years. And so then at the point 20 years later, when they do want to go and use it, that little company now has expanded nationally across Canada and has stores, and you now cannot open your stores there.
Nice.
Who would that be?
What's your strategy for protecting in that situation?
Right. I'll get to it, because what Marla has talked about is the fact that, and again, we'll have a couple of slides, trademark rights are territorial, like a lot of things. The fact that you have registered your trademark in the United States gives you protection in the United States. It does not give you protection in Mexico or Canada or China or Ireland or any other country of the world. And so that is a consideration, and hopefully we'll talk a little bit about it, which is a business strategy. Yes, ma'am?
Is it the same thing with copyright and patents?
Patents, yes. Copyright, the U.S. is the only country that requires you to register it, and so in most countries, when it actually is, pen is put to paper, copyright protection basically is acquired in almost every country of the world. The U.S. is the only one that I'm aware of that actually makes you register a copyright, but patents are absolutely the same as trademarks. You have to register your patent in every country that you want to protect it in, and if you don't,
And someone either steals your idea or comes with it on their own and registers it in their country, and they have it in their country.
well, a trademark for sure. A patent is a little bit different, because patents, and we're not going to get into the deep weeds on patents, but patents based upon, you look at prior art, all the rest of that. If you've been using it in the U.S. and you're using it over there, no one should be able to get a patent, because patent examiners do patent searches. And if they find that there's someone been using that patent, they will look and they'll refuse to grant a patent to somebody who comes in and files it. I mean, if Apple hadn't protected its phones in every country of the world like they do, no one could come in now and basically claim that technology and file a patent for it, because a patent examination is unlike a trademark examination, which only looks at registrations. They look at prior art, and prior art meaning other people using it everywhere. And it's in the United States, people often get refusals because patent examiners will find that there's articles written of somebody using the same technology, in the Czech Republic or something. And so it's a little bit different. But the point of it is, if you want to protect it, you have to decide early on to do something with it on a patent. And it gets real expensive on patents. It truly, that is a $10,000 investment, unlike a trademark. And it's very expensive doing it around the world. Trademarks aren't quite that much. And again, there's certainly a downside to not doing it. And that's a sad story about what are you going to do in that country. And Canada, we'll talk about. Again, it's just an example. We're talking about offensive, defensive, whatever. And a lot of packaged goods companies, again, this was one that I used to work for and was their head trademark lawyer, but a lot of times it's not just a matter, okay, we want to protect our brand name. As you can see, the brand name is NyQuil and the house name is Vicks. You'll have people that get fairly sophisticated on this, which is, we know we're going to get knocked off, and this happened 25 years ago, and we know we're going to get knocked off by private labels and generics. So what can we do to come up with a package that is pleasing and yet has enough protection on it to keep people from doing it? And if you sort of look at this package, you can see that there are several things on here that are protectable. We talked about nationwide slogan. You can see some shapes and colors and whatever. And so you actually wind up registering multiple trademarks, as is in this case. This is an oldie that I always use, and I say to people, okay, how many trademarks are on that? Probably can't see the one in the middle, but the cup, Maxwell House is a trademark. Good to the Last Drop's a trademark. Master Blend's a trademark. The cup with the drop coming out of it's a trademark. And the entire overall package design's a trademark. So you got 5 trademarks.
Could Master Blend be
Oh, how could Master Blend be? Well,
Diligence.
It's descriptive. It's not generic. I was amazed. It's been 25 plus years ago that Nestle had a registration for auto drip. Now, you want to tell me how in the world for coffee? It's like anything else. There are 800 or 900 trademark examiners. Some of them are really good, and some of them stink. And sometimes things get through that shouldn't get through. But you know, why would they do this? It sort of goes back to the NyQuil one, which is, you know, you're going to get knocked off. You want to put as much on there to make it as hard for somebody to basically knock off your package design as you can.
Would it sometimes have to do with whether technology is new, so we have new coffee makers and auto drip is a new thing that's occurring?
Yeah, but I would say I can say this now because I mean, a lot of times your business people that you're dealing with are wanting to use, trademark and copyright and patent law are intellectual property and they're supposed to advance things. And a lot of people, sometimes you get business people that want you to help them use them for anti-competitive reasons. And it comes out in courts when people bring lawsuits sometimes that judges shake their head at and go, why are you doing this? And it's pretty clear that they're trying to use trademark or copyright law or patent law to basically stop somebody from being a competitor. Now, it's one thing if somebody comes out with a knockoff, but on some occasions, you're talking about they just don't want any competition. And so, if P&G couldn't use auto drip on Folgers, then they'd have to use automatic drip. It was really that simple. And so somebody thought at Nestle that was an advantage. Well, whether it is or not, who knows? This is the section that we talk about when you file a trademark application, which is section 1052. Again, all this is online, so it's really good. But basically what it says is you can register a trademark unless it's one of the following. And the first one's pretty obvious. So I think Mary will talk about that as well. If it's immoral, deceptive, or scandalous, or disparaging, consists of a flag, okay, that's pretty obvious. You can't do that. Portrait or signature of a living individual. We had to get Urban Meyer's consent to register Urban Meyer's name as a trademark. And it's pretty simple. You need somebody's written consent to register the name as a trademark. Those are pretty obvious ones. Here are the other two. These are the, yes ma'am.
I just have a question.
Yeah.
I encountered this just by random Googling. What if someone has your exact name? I don't know if the middle name is the same. And let's say she registered it because she has a certain signature and she's an artist.
Mhm.
We have the same name.
Mm-hmm.
So how can she register?
For
the
what?
name?
What's
She's
she
an
registered
artist.
for?
I don't know. I don't know. But-
That's the point. You can't register for everything. What's she registered for?
So she's an artist.
Okay.
So say she has a signature, like she signed her name a certain way, and
Okay.
that's her quote-unquote trademark.
Okay.
So.
Is she using it on clothing
she's
and
on her artwork.
on her artwork? Okay.
So it's just a name. So say
But-
I want to register my name too, but
Yep.
I have a different signature. Can you do that?
Well, yeah, of course you can do that. We represent Harry Winston, the jewelry company out of New York City. And Harry Winston's been a registered trademark for years and years and years and years and years. Actually, we had a case that went on in the trademark office for 12 years against his son, Bruce Winston, who decided he was going to register Bruce Winston, and we absolutely objected to that because it was for jewelry. And so, absolutely, she can register her name for artwork. You could register your name for something else, but just because your last name may be Ford, you can't start a car company and call it Ford.
So as long as I'm not in the same industry, I can still register my name, but
if you're using it on a product.
If you use it as a
So
trademark,
it's
yeah.
based off of use of exactly what you're using it for, not that it's the same name.
Not the same
So you
name.
can have 10 trademarks for Jenny Foster, but it could be all different kinds of companies.
There are multiple trademarks. Now, of course, there's some names that are so famous that they're used on a whole lot of things, but, and you can come across.
It's not really a famous name.
Okay, so, but it's for that, so surely she can, so,
I'm
for
just
artwork.
curious, because I just thought that was interesting when I found that. It was just random, and I've been emailing with her.
You-
But she's an artist.
But she can't keep you from using your name, just.
Only for
So that,
artwork,
you know.
only for
That'd be
artwork.
interesting. What if I wanted to do that for, I don't even know why I want to do that. What if I wanted to do that, but as long as I'm not using it for the same use, based on their use, so.
That's
If you
right,
want to come out with a line of perfume or something, you're probably fine.
Okay.
but not a line of artwork.
No artwork.
So these are the two biggies that you get a refusal on, and that's basically what I said before. 2D is likelihood of confusion with something that's been registered in the trademark office before or is applied for. That's so that it would cause mistake, confusion, or deception. That's likely to confusion. And again, you know, use on artwork and use on aluminum siding are not likely to cause confusion, is the whole point of that. E is we talked about this in general, this is the other one, which is another refusal. Is it descriptive or misdescriptive of the product? You can sort of figure that one out. Is it geographically descriptive? Chicago deep dish. Geographically deceptively misdescriptive. Chicago deep dish by a company that's only in Columbus, Ohio. Primarily a surname. Surname, we'll call it Winston. Or it's functional. Now that's getting into packaging and things like that. Those are the only grounds on which a trademark can be refused. D, if it's the same likelihood of confusion, it's an absolute block. You can't ever use it. E, you can get around that. There's a way to get around on E, and we'll talk about that. Let's just do a couple more and then we'll take a break.
They may have to change C so it says the president or his widow.
Yes.
It's an old law.
That's really old. Yeah, I think, I don't know when that came in.
The dead president.
Yeah, the dead president or his widow. I mean, because, you know,
I don't know if anybody's tried to do it, but.
I don't know that anybody's ever tried to do it, exactly.
I mean, but
don't.
that's why you see George Washington all over
And
everything.
Lincoln.
I don't think anybody.
Abe Lincoln everywhere.
You know, they're.
Again, we talked about this, so applications are either use-based or they're intent to use. Again, once it goes through the process of its intent to use, filed, examined, published, no one opposes, then you get 3 years, and every 6 months you have to pay a fee. But the point is, the date you filed the application is your constructive first use date. So if you don't begin use until literally 3 years from today, anyone who adopts the same mark for similar goods or services, like 2D, you have priority over them, and they're going to get a 2D refusal on the basis of you, and you are considered to have use. So when you file your writ application or your statement of use, it basically goes back to as though it were filed today. What is the trademark office's function? Well, pretty obvious. They tell you that's to guard against public confusion. Again, that's the 2D. Search for 2D similar marks. And examine for procedural issues. Has your description of goods right? Is it, does it make sense? Is it in line? Keep generic and descriptive terms or geographic terms from being registered absent a disclaimer, or, as we talked about before, being put on the supplemental register. And they issue office actions in which you have 6 months to respond and try to convince them of the errors of their ways. And a lot of times you can't. I mean, sometimes these things come out and they're computer generated, and a lot of times you just follow, a simple 2 or 3 page response with a little bit of legal argument, and it's fine. Again,
You mentioned how you might have a name, but have a disclaimer for part of it.
about disclaimers,
Yeah.
yeah. Let me get there. You're reading my mind.
Sorry.
That's you're reading my mind. I know you want to hear it, but I'm just saying. Again, these are the biggies: immoral, scandalous, or disrepute. You aren't going to get it. Likelihood of confusion, you'll never get it if that goes final. These other ones, you can get them through. And that's what we're going to talk about. If it's refused on any of these grounds and you just say, I'm sorry, you're wrong, you can file an appeal to the Trademark Trial and Appeal Board, which is basically the administrative body of administrative judges within the Patent and Trademark Office. You file a brief explaining why the examiner was wrong. He or she responds as to why they were right. You can ask for an oral argument, or you can just file it and they'll rule on it. And if they rule in your favor, then it goes back and the refusal is withdrawn. If not, you're out of luck. And so,
This is saying the percentage of refusals that are upheld by the Trademark Trial and Appeal Board is pretty high. I mean, they come down on favor of their trademark examiner's decisions probably close to 90% of the time.
yeah,
So
they do. They do. Now, this is where Marla was asking here, I think, one of you. Descriptive and merely descriptive and geographic marks that acquire distinctiveness can become protected under U.S. law if they have obtained a secondary meaning. And what is secondary meaning? Secondary meaning means that in the minds of consumers, they no longer associate Chicago pizza with any pizza that's in Chicago. Now that's a bad example because there's so many of them that they wouldn't. But they no longer associate the terms only as being descriptive. They associate it with one product and one producer. And you have to prove that. And so this is the whole point about supplemental registrations and state registrations and the fact that if you get a refusal, there is a presumption. If something is refused on the grounds that it's merely descriptive or primarily geographically descriptive or a surname, if your client has used it continuously for 5 years, there is a presumption that you can then go back and file a new application and register it by claiming that is acquired distinctiveness or secondary meaning. Sometimes it takes longer than that. And the next slide will be, I hope, an answer to that. If I put that in front of you, does anybody know what the brand is? Thank you. Secondary meaning. Folgers coffee, it's mountain grown. Secondary meaning of descriptive marks like surname marks, like geographic marks, is established when you submit to the trademark office. If you get a refusing to register mountain grown, and you say, well, it's obtained and acquired distinctiveness, they're going to say, prove it. And so, to Marla's question, I hope this is the answer. When I was at P&G, Folgers had been using mountain grown for a number of years. They had registrations of Folgers mountain grown. They had registered on the supplemental register. They had registrations of Folgers mountain grown with the terms mountain grown disclaimed on the principal register. And a disclaimer means that you admit, the trademark office said, you file from Folgers mountain grown. The words mountain grown are merely descriptive, and so you must disclaim exclusive rights to them. You get a registration, but you're not going to be able to stop anybody else from using mountain grown for coffee. And so that's what disclaimers are. It's sort of a little bit better than being on the supplemental register, but not a whole lot. What I was able to do is, because there'd been so much use for so many years, and a term mountain grown is very descriptive, obviously, of where coffee is grown, because it's all grown above a mile. It's all grown on a mountain. They don't grow coffee down the valleys, at least they didn't used to. But the point was, there was so much advertising. There were hundreds and hundreds and hundreds of advertising. There were billions of dollars of sales of coffee. There was just hundreds of millions of dollars of advertising spent. And just what we did here, especially 25 years ago, we could convince the trademark office that a consumer no longer just thought of mountain grown with coffee as being descriptive of coffee, that when they saw mountain grown, it had obtained a secondary meaning. That secondary meaning is when people see that, they think of Folgers. At that point, it is now subject to being registered on the principal register without a disclaimer of mountain or grown or mountain grown, and exclusive rights to mountain grown for coffee. Back to her comment, that may be unfair. That may be one of the things that businesses and companies use us to do as little pawns on the chessboard to try to get things for them and use them in an anti-competitive way. But the point was, nobody else was using it as a brand for sure, and it had been used for a long time. And so we were able to register the thing. Just blow through these quickly and then we'll take a break, I think. It's probably a good idea. Anybody know what that is? Is that a trademark? If I put this in front of you, do you think it's a trademark? Exactly. It's Owens Corning. It's insulation. Well-known case back in the 80s. There had not been a single color registered as a trademark, and it was before the Supreme Court in '95 said that you could do that. But the point was, Owens Corning, sort of like Mountain Grown, had been using pink in insulation for a long time. They had been advertising it that way, and they literally filed an application and they described the goods as the color pink on insulation. And it was refused by, maybe not obviously, but it was refused by the trademark office on the grounds that that's functional. Nobody, it's merely descriptive or it's generic because it's a color. It's a color on a single color on a product. And it was the Trademark Trial and Appeal Board affirmed the trademark office, and they took it a step higher to the Federal Circuit Court of Appeals, which decided and said, no, that a color can, under certain circumstances, if it's acquired secondary meaning, been used so long that consumers associate that color with that product, that a company can own a trademark on a color. For a period of time, everybody was filing for colors on stuff, and there aren't many that fall into that category, I guess is all we can say. It's just there aren't. But the point is, color can function as a trademark if it has obtained secondary meaning. Takes a long time.
Tiffany blue. Do you think
There's a
it's-
perfect example.
is
Another
it-
perfect example is Tiffany blue.
It gets into Pantone colors at some point. I mean, it's not every blue out there, but then there will be specific Pantone.
Right.
I was wondering, is the Walmart blue registered? Because I was watching some TV show, and they had a scene in this department store, and in the back is a stripe of Walmart Foods, and you're supposed to think of Walmart. Because instantly I thought Walmart, so I thought, I wonder if that's...
I don't know. I don't know. I've not read anything about it.
I
I'm
doubted
trying.
it. I doubted if they used it in the TV commercial.
That's probably right.
Just-
That's a good point. That's the official Gazette. The old version is now online, but it still used to get books and everything was published in it. There was a trademark application. That's 30 days. Oops, guess I got to do that. 30 days after it's published, anybody that objects files what's called an opposition against it. They say and they got those grounds that are up there: likelihood of confusion, merely descriptive, geographic, etc. Those are the grounds the trademark office can object, and those are the grounds that somebody else can object. And again, one of them is likely to confusion, and I'm a prior user. And again, if no opposition, just blow through some of this. If it's intent to use, you get a notice of allowance. You got to begin use within 6 months or get extensions of time. And at some point within 30 months, you have to submit a sworn declaration, basically with a specimen showing how it's used. All right, trademark usage. Trademark is a proper adjective, grammatically speaking. It should be followed always by a noun. You can't use the R in a circle in the United States unless it's federally registered. TM and SM, people use them all the time, no significance. A lot of countries, this is where companies, sort of back to Marla's question as well, though. If you got trademark registered in the U.S. and you're selling products around the world, do you put the R in a circle on it? Well, the problem is if you do that and it's sold in certain countries where it's not registered, it's a crime and your products can be seized. China is one of them. So if you sell medical devices in China and you have a product and you have an R in a circle next to that name because it's registered in the United States and Canada and whatever, and it's selling into China and you don't have basically a trademark registration, it's a crime and your products can be seized. So you don't want to do that. Again, there's just examples of that. Loss of rights, we talked about abandonment. 3 years non-use, consecutive non-use in the United States creates a a prima facie case of abandonment. You can rebut that by saying, our factory burned down and we're still in the process of it. Genericide, we just talked about before. There's a number of things that are out there. Escalator, elevator, aspirin were all trademarks at one point. Over the years, people started using them as generics. There weren't other products. Shredded wheat was a trademark at one time, and they become generic. Again, back to my own experience, at one point before there were anything called Huggies, because the patents were so strong, the only product that was sold for several years was called Pampers. And in a lot of countries, Pampers actually became generic. Didn't in the United States, but it became generic as a name for disposable diapers simply because there was no other competitor out there that was using it. So you can lose your rights that way. Preventing loss, again, a lot of times you'll see companies that they'll amend it. You can amend your actual mark if it doesn't change it substantially, or you have to file for a new one. This is an example of Betty Crocker, I think. I'm not a Betty Crocker aficionado, but the one on the right is how she looked years ago, and this is how she looks in modern day packaging. That's Betty Crocker's a trademark. If you can see a photograph of somebody, if put on a product and it's sold, it can be a trademark, just like a name, that can be a trademark as well. Again, abandonment, defined, discontinue with intent not to resume use. Usually, again, you do a search, you find somebody's not using it, you tell your client, they're interested in it, you tell them to file an application, it's going to get blocked. What do? You file a petition to cancel this. Actually, what you normally do is you write the person that owns the letter and say, we understand that you're not using it, we can't find any use. Can you please tell me if you're using it and where? And if not, will you either assign the registration to us for a nominal fee, or will you voluntarily cancel it? And sometimes people are good about that. Other times they say go fish, and you have to spend time and exercise and money to get rid of them. But again, the point is, the whole theory of U.S. trademark law is use it or lose it. It is not like a patent that is good for 20 years, whether you use it or not. It's not like a copyright that's good for 100 years. Trademarks can be protected forever. Ivory is a very old trademark for soap, but if it ever stops being sold, it will basically get abandoned. The registrations will get canceled, and if somebody wants to adopt Ivory for soap, they'll be able to do it. And this is a case in which, again, Trademark Act doesn't allow you to preserve things. And a lot of times you hear clients talk about, we want to bank this name, we want to do something to protect it, we want to make token use. That all went out the window with the Trademark Law Revision Act of 1989. This was a case that was before that, but Exxon used to sell as under Humble. Another company came out and started being in the oil business, calling themselves Humble. Exxon sued them. The point was, Exxon was told, look, your name was Humble. You changed your name from Humble to Exxon in 1970, whatever. You can't basically bank a trademark, and that's the theory. No matter how big, no matter how many billions of dollars of Humble products you sold, you can't do it. Tomorrow's question. Trademark rights are territorial. Trademark registration in one country does not provide any protection. Most countries are civil law countries, unlike the United States, which is common law. Common law means if you begin use, you have certain rights in a certain area. In most countries, it doesn't matter if you've been using it for 20 years. If you don't have a registration in China, the fact that you were using it for 20 years, somebody can come along and register that trademark, and they can tell you to stop. That's what most countries are around the world. They're civil. Again, the Paris Convention, all these treaties do not provide substantive rights to protect their name. And again, there's a famous case involving Pernod Ricard and claiming rights to Havana rum. If you don't use it, you lose it, which is going to be interesting now that Cuba and the United States are back doing business, that who will have the rights to Havana rum? A lot of these things were canceled. Yes, ma'am?
If you do have to go outside the United States to register, do you have to have an attorney in that country assist you, or is that something you often do?
We often do it, and a lot of times companies will have us do it simply because it's more cost effective for us to do it than having somebody in-house do it. And the fact that we've got a network of people that we've dealt with for 38 years that we know. One of the problems about, just like in the US, I think, is knowing who to deal with. There's a lot of good lawyers in the United States, and there's a lot of crappy lawyers in the United States. And so To your point, you can go direct, and if you've got a big enough legal department and you've got people that want to do that, and they're interested in managing the foreign portfolio, they can do it. And we had a conversation during the break, and that's why I'm laughing and saying it. But to your point, no, you can certainly do it. You can deal directly with a foreign counsel and say, I own this trademark, my client owns this trademark in the United States, we'd like to register it in your country. There's a whole lot of different treaties and things that have come into effect in the last 15 years that everybody thought, a lot of in-house people thought was going to be this great money saver. The Madrid Protocol, which big fancy highfalutin term, that in other words, if you had a registration in the United States, you would send it to the World Intellectual Property Organization and say, I want you to send this out to all these countries and register it and avoid an attorney. But the problem is in all these countries, it's like the US. You file something in there and you get an office action. Now you got to hire an attorney there anyway. So what have you dealt with? I mean, the only one that makes any bit of sense is what's called a community trademark, and it's a single trademark system for all the countries of the European Union. So you get one application and it covers all 28 countries of the EU. That's about it. But all these other things are just, and it does get a bit complicated as to what you're doing, and especially, are you going to do searches? I mean, you can talk about how much expensive it is. The lady back there was asking before about what's it cost in the U.S. Well, you start doing searches, but if you don't do searches, I mean, we just had a client that got acquired by a bigger company, and the client that we were dealing with had an in-house IP department, but their view was to not do trademark searches, just to file. The company that acquired them, basically their IP department is, why would you ever spend the money to be filing trademark applications in all these countries if you didn't know that you were going to get it registered? My answer to that is I'm with you. I agree. But it's just a matter of a business strategy, and somebody never told or had the whatever to tell the business people, if you want to protect it in these countries, you're going to have to basically search it, file it, register it. And then most countries are like the US, which we're talking now about abandonment and rights. And you can get a registration, and in most countries within 3 to 5 years, if you get a registration and you're not using it, the other part of this is, just I'm backing up here, I want to get quickly through this. Unlike the US, almost every other country does not require you. The US requires you to swear that your client has made bona fide use of the mark in interstate commerce before you get a registration. No other country in the world's like that, not a one. So you can get a registration without having used it. You can just file it and get a piece of paper. Now the problem with those is that they do have a provision like the US. Most countries it's between 3 and 5 years. If your client hasn't begun to use it within 3 to 5 years, then that registration, much like one in the US, is considered abandoned, and if somebody challenges it by doing a search and wants that mark and files a petition to cancel it, they can cancel your registration. Did I go too fast? Everybody with me? Okay, good. Yeah, so there you go. Most countries, first to register, not use, gain rights. Distinct laws, civil countries, common law, which is one of the problems with the community trademark in Europe, which is because, other than the UK and Ireland, every other country in there is a civil law country. And so everything, even if you have a community trademark registration that supposedly covers all 28 countries, if you seek to enforce that against someone, you're going to have a very different result if you sue somebody in the United Kingdom, in England, and they apply common law, or you sue them in Germany and they apply German civil law. We could spend all sorts of time on that, but we don't have all sorts of time on that. Again, the biggest key is registration in one country doesn't give you rights in another, and use in one country doesn't give you rights in another. I throw this up simply because I think I put this on the slide. In most countries, one of the things that you do, English is not spoken in most places in the world, and so not only you have to register, your name, Budweiser in China, we had come up with basically Chinese characters. And are you going to have Chinese characters that sound like Budweiser, or are you going to try to have one that have some sort of a meaning. And so you sometimes wind up not only having a registration of the English characters, you have a translation, and then you have a transliteration. So you got 3 registrations that cover the same product. Because Budweiser, if you transliterate that, means nothing. So ultimately what they decided to do was come up with Chinese characters that translate into byway, that's sort of similar to that, but means 100 powerful in Chinese, which they thought was a really good name for Budweiser. So there you go. So the worst of all worlds. I spent 4 years of my life on this. Mary's heard me tell this story too many times. Goes back to the fact that in 1908, Anheuser-Busch and 2 Czech breweries that were based in the city of Budweis, which is what it was called in German, or České Budějovice in Czech, basically had their first run in the United States, and they signed an agreement that didn't cover the whole world. They signed another one in 1939 that still didn't cover the whole world. And so there is, for those of you who have been to Europe and other places, there is another Budweiser. It is called Budweiser Budvar. It is a brewery that's been around since 1900. Anheuser-Busch has been around since 1860. And one of the saddest things that I saw during my time there was going through old files and looking, to your point, basically came across a memo. I just remember it'll always stick in my mind, from an outside lawyer to August Bush's father, Gussie Bush, basically stating that the Czechs had filed, the Czechs meaning the Budweiser Budvar people, had filed to register Budweiser in Italy, and it would cost approximately $300 to oppose it. This was like in 1960, and their response was, nah, don't waste the money on it. During my time there in the mid-90s, early 90s, we had litigation in 62 countries over that. Places like Germany couldn't sell it. A lot of places around the world where you couldn't sell it simply because Budweiser Budvar was there first. They registered it there, and so you wound up spending your time trying to come up with other things like that to be able to use to sell your product in other countries. And those 3, all 3 of them in Germany, wound up getting lawsuits by the Czechs on Budweiser Budvar and getting prevented from using them. So it is truly one of those things where, what do you do if you have a client? I mean, I think for retailers it's really a tough thing, because that's the whole point. They don't have brick and mortar stores anymore. So what are they going to do? Now that you've got online, you probably have some use. And if you're starting fresh today, if you register your trademark for online retail store services in the United States, then you can register, assuming no one's already using it in major countries that you want. You can register it for that, and you can document that, in fact, you've been selling products in that country. In the old days, when I think what Marla and I are talking about, it was, Sears had problems with that for years, going back to the 70s, with people starting Sears stores in Australia and places like that, where Sears Roebuck never operated. And so once they decided they did want to operate and they'd go in there, it was real expensive if they could ever do it, just because of how much money it was going to cost to buy somebody out to use the name. So, there's no silver bullet to it. The point of it is, if you have a client that is in that position, that is going to use things internationally, I mean, they have to spend some time and effort and sit down and not simply say, let's not spend $300 to challenge somebody in Italy and then wind up giving away a market that's worth billions of dollars in sales. They have to think it through. And I know it's one of those things where not many people have that kind of a client, but some of us do, and I'm sure some of you either have or will encounter that. And so the point is, you have to sort of think it through. I mean, there are companies, and I've been involved in acquiring them, where one of the strategies that they use, I don't know it's necessarily the most cost effective, but to Marla's question is, remember what I said, in most countries, 3 to 5 years of registration is vulnerable to attack on the grounds of abandonment. And so literally, they'd have ticklers set up, and they'd refile every 3 to 5 years in that country and get a new registration and let the old one lapse. And that was their way, at least not having one that was abandoned, so that if they had to challenge somebody, it wasn't going to get canceled for abandonment. Now, are you going to get into major litigation with somebody who's using it in that country and all you've got is a registration and you're not using it? Probably not. Probably not. But it happens, and it certainly happens to having oppositions, and we'll get to that very quickly, I think. One of the things, this is what's called a watch card or watch notice. They're now mostly electronic, but the point is, as you can see down the bottom, this was, down the bottom, you get them every week. Your clients have their marks under watch, and the one down the right bottom, or the left bottom, was not filed by my client. It was filed by a crook, and that was Indonesia. So you wind up seeing those. What do? You have to contact a local lawyer, and if you're going to try to oppose it on the basis of your registration or the fame of your mark worldwide, there's lots of ways that you can attack it, and there's a lot of countries where there are a lot of crooks that try to register famous marks, whether they're American or some other country's marks. These are called watch cards, and again, there's another one, very obvious rip-off is what it was. It wasn't by AB. Okay. You gonna take from there, or am I going there? I can blow through that. All right, I will. What is trade dress? Again, we talked about the Folgers, or the Folgers can and the Maxwell House can. Trade dress is, generally speaking, legally considered the overall look and appearance of a product and packaging. This is a lawsuit that we were involved in 10 years ago now. We represented Britney Spears, and we sued this knockoff package here in Columbus in federal court, and got it enjoined on the basis that the packages were similar. We didn't have a registration of the package design. We all know now we can register package designs, but we didn't. But we had significant use, a lot of use, and the fact is that this was a fairly distinctive. There was no reason to have to acquire secondary meaning, acquire distinctiveness. This was the people who designed the package on the right for Britney Spears testified about how they went about it, that it was not meant, it was very clearly meant to be distinctive on its own, and the judge agreed with us. So the point of that is, must trade dress be registered to be protected? The answer is no. This is the section of the Lanham Act that basically protects unregistered trademarks. If you've got an unregistered trademark and you can establish that it is distinctive and it functions as a trademark, and you've been using it before somebody else, you can sue them under federal law, even without a registration. Now, it's not presumed valid. That package isn't presumed valid. You've got to put in evidence to show that it's valid, that you have prior use than the other side, et cetera, et cetera. So that's the reason why you want a federal registration. But a lot of times when people get knocked off on new products like this, they don't have time. The lady asked the question before, how long does it take? And it does take about a year. So if somebody knocks you off in the first 3 or 4 months, you can't sit around for a year and wait for your registration to come through. So you have to sue them on those grounds that basically, it's unregistered trade dress. This is one of the original cases. It's on trade dress being protected. It goes back to the 80s. Ultimately, Scott's acquired this business and then literally changed the package after they had a federal court for the first time say that packaging and colors on packaging can be distinctive, can function as trade dress, in which they basically successfully sued Chevron, who owned this knockoff company. They basically sold the business at Scott's, and the package designers changed it. So I'm not sure what it looks like now as far as the package. I haven't looked at it. Trade secrets, again, just one of the other pieces of intellectual property. It's something that's useful in your business. It's something that you protect. You don't let everybody have access to. You take all sorts of precautions to keep it from being disclosed. And the problem with this is that unlike Coca-Cola's secret formula or the KFC secret formula, a lot of times companies will use this to claim a worker left with trade secrets and is going to a competitor. And then when you wind up going in there and find out that everybody and their brother and sister in the company had access to these things, they were on the network, etc. If it's a trade secret, it's kept under lock, it's kept under key, and only certain people can have access to it, and only at certain times. And the problem is that most of the time, companies and businesses don't call something a trade secret until somebody's walked out the door with something that was never considered a trade secret, and then they want to go after them and do something on it. Patents, again, functional features, novel and unobvious. We talked about it. Prevents somebody from using it or selling it. A fixed term. It lasts for 20 years. It's federal law only. There is no state patent system. There is no state copyright system. Design patents are sort of a cross between a copyright and a trademark. They must be ornamental. If you look at like a shoe, a design, an ornamental design on a shoe, for example, can be a design patent. A lot of bottle designs are patented. In other words, soft drink bottles will, I think Mary may get to that as well as not, but there's a lot of crossover. The Coca-Cola bottle, the old one, was covered by a design patent for 14 years, back when 14 years was a design patent. It became so, it acquired distinctiveness, had secondary meaning, people recognized it, and during that 14-year period when nobody else used it, it functioned as a trademark. And so when the design patent expired after 14 years, it was protected, so long as Coca-Cola used it, as a trademark. So there's a lot of crossover here. The problem is when people try to misuse one, again, to the whole point we talked about, for anti-competitive behavior. And with that, I will pass it on to my partner. You gotta do this double-handed. You want a trade? That's fine.
Okay. I know this is what you all came to hear. Far more interesting. The dog is our, we're trying to get this dog associated with our practice, so.
It's my dog, by the way, so it is my dog.
Everything that we can do to establish
And
secondary meaning in the dog.
he's sleeping in my office as we speak.
Probably wants to go out for a walk by now. We saw this before. There's a tremendous amount of trademark litigation that's been going on over the years for various things. These are some kind of interesting cases that have come up recently. Most trademark litigation has to do with a likelihood of confusion. A company suing another company because they think that their mark's being infringed. Recently, there have been a couple of interesting decisions that actually have to do with the registrability of the mark. And as we saw earlier, this 2A, or Section 1052A of the Trademark Act says that you can't register a trademark that consists or comprises of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. As you might imagine, there's a fair amount of subjectiveness to that, and you may be aware that perhaps the Washington Redskins have been in this on. This is the section of the Trademark Act that was being argued over with the Washington Redskins case, and whether Redskins is disparaging or not, and whether that could be whether their registration was canceled. And I think you may be aware that the Redskins trademark was canceled by the TTAB. But this is a very recent decision from the Federal Circuit. And the Federal Circuit, the way it goes, you have the Trademark Office that determines whether a mark can be registered. If you don't agree with the decision of the Trademark Office, you'll get it reviewed by the Trademark Trial and Appeal Board, and they'll probably affirm whatever it was the Trademark Office said, and then you can take it up to the Federal Circuit, which is like the Sixth Circuit, except it's in Washington, D.C., and it reviews the decisions of the Trademark Trial and Appeal Board. So the Slants, which was an Asian rock band, wanted to have the registration of the term the Slants, and it was they were refused registration on the basis that the term slants was disparaging to Asians. Now, the fact that it happened to be an Asian band that wanted to have this didn't seem to make much difference to the board, so they fought this pretty hard. And what was interesting is that what came down was that not only did the Federal Circuit says, yes, you can have your trademark registration, they ruled this entire section of the Lanham Act unconstitutional out. It's an abridgment of free speech. The disparagement part. It said, it's gone. We're not going to, so we have no idea what's going to happen. There's a whole lot of what we call the 2A refusals out there that are waiting for some reviewing court to decide what's going to happen. But it's interesting. I mean, probably it'll go up to the Supreme Court at some point. I guess in this politically correct age, it had I think it had finally gotten out of hand, because there was not a whole lot of uniformity among trademark examiners as to what was termed disparaging. There's something that the PTO denied the mark, "Have you heard Satan is a Republican?" because it disparaged the Republican Party, but another examiner undoubtedly found that the mark "The devil is a Democrat" allowed that to go through. So there was one office rejected a registration of "Fag Forever a Genius" and "Marriages for Fags," but accepted a mark that was F*A*G, fabulous and gay. So, I mean, there was no real, what is disparaging? And that was part of it, was the lack of uniformity. The other part was that, and the court went on about what the importance of, what the economic benefit of a trademark registration is. And that by not allowing, for preventing somebody from getting a trademark registration basically on content-based speech, that they were it was causing economic harm, which was an interesting way of looking at it. And also the interesting part was that it went onto the constitutional area, and we'll see another case later on where a trademark case was decided not on your traditional trademark grounds, but on speech grounds. And the circuit judge on this, writing for the majority, said, "Courts have been slow to appreciate the expressive powers of trademarks. Words, even a single word, can be powerful." Mr. Tam named his band the Slants to make a statement about racial and cultural issues in this country. Many of the marks rejected as disparaging convey hurtful speech that harms members of stigmatized communities, but the First Amendment protects even hurtful speech. So we'll see how all this comes out. It's interesting. As we say, certainly the Redskins decision. This is the Eastern District of Virginia has affirmed the rejection of the Redskins registration, and no doubt this is going to be appealed, and we'll keep hearing about it. But there's a whole list of. When it got to the point that Squaw Valley was determined, Squaw Valley, the ski resort, that was found to be disparaging. At some point, I think things kind of get out of hand, and anyway, we'll see what happens. This is sort of breaking news, and so now when people talk about the Redskins, you'll have a little more of an idea of what was going on with that.
I don't have any idea. So and I've been following it. A friend of mine filed the first case in 1996 trying to cancel the Redskins, and I didn't understand what he was doing when he said that. And here we are 20 years later, and it's still bouncing around. I get the whole point of it, but I don't get the point of it. It's like it's an old trademark. If the fact is, if you don't want to support them, fine. But the fact that it's registered, it's a registered trademark. There's a lot of junk that's registered as trademarks, and as Mary said, one could as easily take the position that a registration of Fighting Irish with a picture of a little leprechaun with a beard and his fists up is disparaging to people of Irish descent as they could that. And if that's what is going to be imported into it, and I don't want to get in the middle of it, other than the fact that it really started off with the OJ case. You want to mention that?
Oh, you go ahead.
Right after that, Johnny Cochran filed a trademark application to register OJ for a whole bunch of goods. Now, why anybody would want to after the trial of OJ Simpson, but he did. And some guy who had nothing to do with it filed an opposition and said that, while I don't have a business, there's a standing issue there for those of us who talk standing, but I'm a moral, upstanding Christian man, and that offends me, and I think it's basically, it's scandalous that he can register his name. And the Trademark Trial and Appeal Board, this is when the thing started to hit the fan, said, this man has standing to argue that OJ as a trademark is scandalous. And I remember at the time reading that and going, that is really some bureaucrats that are taking it way too far for whatever it is, because you can find almost anything you can get upset with. And these have all sort of come after that, to the point where you got Asians trying to register something, and then probably somebody who's not an Asian telling them that it's offensive, whatever.
All right. So, this is when we were also talking about some of the. Remember the 2E refusals for something that is functional. This is actually a Trademark Trial and Appeal Board affirmed a refusal to register. Big surprise. But the assembly of this, I mean, you can't register that as a trademark. It's functional, and that's why that is simply something that cannot be registered. If it's people with design patents or regular patents, sometimes try to extend their intellectual property protection, because if you can get a trademark registration, you've got that forever as long as you're using it. And so a lot of times there will be efforts to extend protection beyond what is appropriate, and in this case, they didn't get away with it. Joe has alluded to the idea of oppositions. An opposition is something that happens within the trademark office, and it is if you see some registration that has or application that has been published, and you think that you're going to, any person who thinks they may be damaged by that, basically, if you think that not Mr. OJ, but if you have a business and you think that this trademark is something that's confusingly similar to something that you're using, then you can oppose the application, and if you are successful, then the application will not register. There's also a means for canceling of something that has already been registered. Certainly within the first 5 years of the registration, you can say, whoops, I just saw this is harming my business, and then you can seek to cancel the registration. These...
And it's on the same grounds that we talked about, 2A through 2E. Those are the grounds that you can oppose something on, right?
So...
Immoral, scandalous, merely descriptive, likelihood of confusion, primarily geographic. Those are all the grounds that you can oppose.
Now, in front of the TTAB and you can also, again, file a lawsuit against somebody who's actually using a mark in federal court, and, kind of based on the same sorts of things. The TTAB is a little bit, it's an administrative body, and if you've ever worked with administrative tribunals, you know that it can be kind of bureaucratic, but they have a very proscribed jurisdiction, what it is they can do. They decide whether to grant registration, and that's what they do. And they do not, you have a trial in a TTAB action, but it's all done basically through depositions. People come, give depositions, you present evidence, it has to go in under the rules of evidence. Everything is submitted to the board, you write a brief, and then they make a decision. You can't, and the decision is only whether the mark registers or not. You can't get an injunction, you can't get damages, you can't get attorney's fees, even if, so it's very, very much more proscribed. So, but the point of filing an opposition is to prevent something from registering, and maybe that's enough. But there are the way that the TTAB's reasoning has now kind of gotten imported, interestingly, into federal court decisions. The TTAB will make a decision based on likelihood of confusion, based on some pretty specific factors. They're very similar to these. Oops, that sounds right. Anyway, it has to do with the length of the time the mark's been how strong is the mark, the marketing channels, all these. But the TTAB really just looks more at the marks in a vacuum, and they do not take into account as much what's going on in the marketplace. And so the sight sound meaning, do the marks sound alike? What's their commercial impression? And it's a narrower kind of analysis than what goes on typically in a district court where, and usually because in a district court situation, you're not going to sue somebody unless they're actually using the mark, and so you actually have a history of marketplace use and who the customers are, and you can do surveys to determine consumer recognition and all that. So there's a lot more evidence available in a district court. Well, in this particular case, the Supremes here said that a TTAB finding on likelihood of confusion based on those narrow grounds could be preclusive in a federal lawsuit for infringement, which
Huge.
which we find kind of
Mind-boggling.
Makes oppositions much more important now.
Everybody done an opposition or worked in an opposition? You have, okay.
Yeah, I mean, the outcome of them now becomes much, much more important because you can walk into, if you walk into federal, it used to be, well, if we lose there, we'll just sue them in federal court, okay?
We start over.
And we'll start over. And it used to be that you could just start over, and certainly even now you can provide additional evidence and that sort of thing to the trial court. But the fact that whatever these findings are by the TTAB could be preclusive is kind of something that's shaking up our world a little bit, and we're not sure, again, how all that's going to shake out, but that was interesting.
It's much more of an Alice in Wonderland. It always had been much more of an Alice in Wonderland approach in the Trademark Trial and Appeal Board, simply because, as Mary said, some things were being used, some things weren't. People didn't spend the same kind of money that they spend on a federal lawsuit. It was a way, it was sending a signal to somebody, we don't want you to have this registration and we'd like you to not use it. And most companies were smart enough to either decide if they lost, they'd stop using it, or they didn't want to fool around with it and they just abandon their application and come up with something else. Now what it says is if you get opposed, you're in it for the long haul unless you pull the plug on this thing, and you better put in the kind of evidence that you would put in a federal court in a Trademark Trial and Appeal Board proceedings, because if you don't and the decision's bad, that decision there may just get plopped into a complaint, and you're going to mention a case right now in which that's happened, right?
Which one?
Out of the Eastern District of Virginia, there's a case.
Did I leave that one?
Well, I don't know if you pulled it or not.
But yes, it has happened that, and that was on a, I think I probably pulled that one. Yeah, I pulled that one.
Anyway, there was a case recently, just came out of the federal court, Eastern District of Virginia, where there had been a trademark opposition in one way, it came down, then somebody filed a lawsuit against the same party, and the court said, I find that the findings of the Trademark Trial and Appeal Board are binding on me, case dismissed. And so that's what's going to happen, because like everything else in life, you tend to get, certainly you find lazy judges like everybody else, and if they can get a case off their docket by saying the Supreme Court's told me that I can accept those findings that the Trademark Trial and Appeal Board already made and I can get rid of it, I'm going to do it. And if you don't like it, you can take it up on appeal and tell the appeals court that the Supreme Court was wrong.
So the federal court is granting authority to the TTAB that it did not originally have. Is that governed by the Congress?
Supreme Court is saying that, well, as a governed by the Congress, certainly the Patent and Trademark Office is. Trademark, again, the difference is they're not Article III judges in the Trademark Trial and Appeal. They're administrative law judges. And everybody, we'd always taken a position, everybody did, their findings of fact were important and they might be considered a little bit, but not really that much. And now the Supreme Court has made some just incredibly, in our view, I guess, assumptions that we just don't think are in fact the case, to simply say, well, it's basically doing the same thing and there's no reason why those findings by the Trademark Trial and Appeal Board shouldn't get imported in under certain circumstances into a federal lawsuit. And again, as I said, we look at it as it's relieving telling a federal judge you can get a case off your docket and get rid of it and just say the TAB already did it. It really makes a decision if it's a serious issue and a company that's using it, do you fool around in the TTAB or do you sue them? I think.
Yeah, and that's certainly part of it. I mean, again, it does make a TTAB proceeding more expensive. I mean, you might even have to bring in an expert. We never used to do experts in the TTAB. I mean, an expert doing a survey, or something like that. I think the Supremes were saying that the Trademark Trial and Appeal Board judges, they're the experts in trademark law, and that's why we'll take their findings because they are the experts in this. And I think now the Trademark Trial and Appeal Board is going to be a lot more careful in its opinions to say exactly what it is finding on, that these facts lead it to conclude this. And so that if it does end up in federal court, you can say, well, they didn't find on this, and I have additional evidence, and you can do this. But it makes it certainly more complicated for people who are practicing before the board. It makes it more complicated for the board writing the decisions. But I will give them credit that they do actually read all the evidence and do a decent job on evaluating the evidence, more so perhaps than a district court will. But there are some issues that it seems that, especially marketplace use, that, especially if it hasn't really happened yet, that at the Trademark Trial and Appeal Board stage, that would be better in a civil lawsuit. You used to think of the civil lawsuit as, well, this is the common sense part of it. I mean, if you can get the Trademark Trial and Appeal Board, that's the real technical stuff. That's the down and dirty trademark stuff. But, if you can get in front of a jury or in front of a court and kind of argue common sense, that, you'd have a chance, So not so sure whether that works so much anymore. Okay, this is Section 32 of the Lanham Act, which is the for infringement of a registered trademark. And again, this is what you would, if you were going to file a lawsuit, these are the grounds for filing a lawsuit in federal court. Basically talking about it kind of like the language in 2D. Something is confusingly similar. And these are the sorts of things that are analyzed in a federal lawsuit. The strength of the mark, something like Kodak obviously being at least at one point, a very strong mark. Maybe not so much anymore. How is it, how long has it been used? How much goodwill is in the marketplace, and which is shown by things like advertising, marketing, that kind of thing. But the thing that how strong are your rights in this mark? How similar are the two marks? How similar are the services? The closer it's kind of a sliding scale. The closer the marks, the less similar the services need to be. Or if the services are identical, then the marks don't have to be quite so similar. It just kind of this is really kind of common sense. Who are they sold to? Channels of trade, that kind of thing.
Can I ask a question that kind of goes back a little bit?
Mm-hmm.
Is the procedure, can you, if you have you believe your trademark has been infringed upon,
Okay.
do you have to go through the TTAB first, or can you go directly to federal court?
You can go if it's federal court. If you
So with this rendering of an opinion from the Supremes about the validity and the authority of the TTAB, why would you even go to the TTAB?
Well, and on a cancellation action, that could be.
A lot of times you got a use-based application now,
Yeah.
right? Remember we talked about that. A lot of times it's cheaper, it's easier, it's much more cost-effective to begin use and then file your application.
If you're going to get an adverse decision and you basically can't appeal it by taking it on to the federal, why would you go there in the first place?
Well, you can appeal it.
I can see, wow, that just boggles my mind.
Yeah.
That's an overstep of authority.
Well, it's not quite as bad as it's just preclusive. I mean, there are, like I say, there's different evidence that you can introduce new evidence to the trial court. It's just what has happened is that the weight of authority of the TTAB has become more important. The federal court still has the ultimate authority over whether a trademark is registered or not. I mean, they can cancel a registration. Federal court can do that, and even if the TTAB said, hey, this is a good registration, federal court can come in after a lawsuit and say, no, we're going to cancel it. So they have the ultimate authority there, and they can still make the ultimate decision. It just makes it a little harder in a case like this. So, and again, makes the...
Well, the most disheartening part is it shows, given how brilliant the Supreme Court is and all their clerks and everybody, it shows a real lack of understanding of trademark law, of basic trademark law, and how the system works.
Well, and the client is the one who gets, the bad end of it. I mean, they get.
Yeah, they get the bad end of it.
I can think of a few vernaculars, but I can say.
Yeah, I mean, it certainly makes things more complicated. I mean, when somebody says, oh, we're just doing an opposition in the trademark office, you don't think of the implications of that if you lose, so. Okay, and here are the remainder of the factors again, if you can show, this is like the Holy Grail, if you can show that the junior user intended to copy your mark, well, you're home free. That's something that, again, these sorts of things are sort of considered by the TTAB, but not as thoroughly.
Competition.
What?
Because
I mean, that sort of thing, an intent to, that kind of comes more under the rubric of unfair competition, which is the TTAB will not look at cases of unfair competition if you're talking about how somebody is competing unfairly in the marketplace, and therefore their trademark registration should be canceled. The TTAB is going to say, well, I don't do that. Take them to court. We don't do unfair competition. So, there still is a role for everybody. It's just been changing. This is an interesting, again, there's so many different types of trademark infringement. And I'm not sure, we're actually fairly sure we don't agree with this one. This is the Ninth Circuit, which is California, and things are different out there. And I'm sure you've all done a search on Amazon if you're looking for Bulova watches, and you type in Bulova, and all kinds of stuff will come up that aren't Bulova watches, because Amazon doesn't sell, or doesn't have a seller that has Bulova watches. And they very well may say, we don't have any Bulova watches, but hey, we've got this. And so, in this case, these multi-time machines sued them and said, well, that's trademark infringement. It's kind of bait and switch almost. And the Ninth Circuit said, no, it's not. And not only said, no, it's not, they did it on summary judgment, which means they said that as a matter of law, that no reasonably prudent consumer coming across something like this would be confused, as a matter of law. So that's kind of out there, and we hope that doesn't stand, because that seems to me to be extreme. I don't know. What do you think? What are your thoughts on this? It doesn't
just buy everything off Amazon, and so when it
Right.
comes up that way, I know that it's not what I'm looking for, and they give me alternatives, so.
Right.
Okay.
And these people simply said, just put something up there that says, we don't carry MTS watches or whatever they were.
Yeah.
And Amazon said, you. And because when people put in our trademark, you're trying to get them to sell something else. That's the point. And you're not telling them, we don't sell them, but if you'd like something else, here's other things that we've got. That was their whole point. That by doing that, that's basically unfair competition. They're passing off other products as being the equivalent to theirs, which they may or may not be, and they probably aren't. If you wanted one of those watches, I don't know of the other ones that came up. I bought stuff off of Amazon like you did, and it's like, well, that's not what I want. And I think that's their point, which is, if somebody does a search on us, just simply say you don't carry our product.
So, but again, interesting thing that it's just simply as a matter of law, nobody is going to be confused, and that's kind of unusual. Usually, this sort of thing, and there are certainly opinions where you know, there are things that if we want to know what the reasonably prudent consumer thinks, I guess we better go to a jury and find out what the reasonably prudent consumer thinks. Well,
I was gonna say, with all the dumb stuff that you see on the internet and Facebook of people doing and believing nonsense that's out there, to assume that they're sophisticated like the people in this room, I think is a stretch for 330 million people. I think there's a lot of gullible dopes.
Was it Amazon, the argument that there was some extreme cost or difficulty?
No.
No.
No, we just don't want to do it.
yeah.
We'd just rather be able to put up something else than have you go to it without telling you that we don't carry that watch or it's out of stock or whatever.
So.
Kind of a big bully. Again, you know.
And you know, and it's interesting as the internet has evolved. There were a lot of very early on initial interest infusion cases where people were led astray and thought that they were looked at something and oh, well, look at this, and now and this is kind of it is sort of that. I want a Bulova watch, and now I'm getting this. Oh, well, I'll just go off and look at this, when what I wanted was something different. I guess just to show how that has changed over the last 15 years now, that somebody can use your mark, Bulova, want your product, and so clearly that's being used to try to sell the product because that's what you typed in, and then here comes a bunch of stuff of your competitors.
And the other part of their argument, the plaintiff's argument was, other retailers do that. If they put in our watch and they don't have it, they'll just simply say, don't carry it, or whatever. Just like when you go to eBay, you can put something in and you'll get 0 hits. It won't, you'll know that there is no such thing. If you want to look at other stuff, you can do it. But whatever you're asking for, they don't have.
So, again, it's the Ninth Circuit. All right, so here we are. When your client is saying, well, can I register this, and will I get sued? Isn't that fair use? Remember that those sorts of things are defenses once you get sued. And so as part of the assumption of risk, you might say that, yes, this trademark or this is completely defensible, but again, it's a defense, and defense only comes up after you've already been sued. I'm sure everybody's heard about fair use. It gets thrown around a lot. Oh, well, that's fair use. I can use it. And again, the internet has made that, because it's there, I can use it, and nobody owns it because it's on the internet. It's kind of a circular argument, and it makes a real problem. But classic fair use is the use of the term descriptively, other than as a mark in good faith, only to describe the user's goods. So. Now, and you certainly heard the Super Bowl and all the kerfuffle that the NFL goes through every year, that nobody else can use Super Bowl, and but you can't actually say the Super Bowl is going to be on CBS this year or whatever, because rather than go through the contortions of the big game, the championship game. Major League Baseball, I think, has, what are all its registrations for the Subway Series and all these kinds of things that you would consider in a sports thing. March Madness is something that has a trademark registration. So people really get out there and try to stake out a lot of turf.
If you don't buy a sponsorship, they don't want you using their marks. That's the bottom line.
It's all about money. But sometimes there are ways that you're not, if you're an author and you're writing a book and the character in your book goes and gets a Coke, you're not infringing Coke's trademarks. That would be, you're just using the mark to describe the goods.
Yeah, we had to do that seemed like every year around Super Bowl time, we had a new marketing team. Reviewing marketing. No, we can't use Super Bowls.
Right,
right.
or footballs, or all that kind of thing. Yeah, it's pretty frequent. Anyway, this whole thing got started years ago. Again, the Ninth Circuit, back in the '80s, I guess. Was that
91.
91. Okay. close to the 80s. It's New Kids on the Block. So, and there was this had to do with a newspaper contest or something, and people were told to write in and say who, there was a concert coming up, and to get interest, oh, who's your favorite new kid? And, we sued them. Said that you're making use of our mark, and the decision ended up being that no, we're just using your mark to describe you. We're not infringing, we're just using it. And so that's been called nominative fair use. We're not trying to pass ourselves off as anything, we're talking about you. So, which seems to be fairly straightforward. Then there's parody. Parody is really tough. What is a parody? I mean, this is actually from language in a court decision. That somehow a parody must convey two simultaneous and contradictory messages, that it is original, but that it's not original, and that's a parody, and have to differentiate from the original, but communicate some sort of satire, but the mark has to be pretty well known, or nobody knows that you're making a parody of it, and after all that's said and done, even if it's a parody, you have a right to make money off of it. And there are plenty of, this was a fairly recent decision where I guess they didn't think it was a good joke.
You did not think it was a good joke.
Yeah, but this was a trademark office, wasn't it? No.
Southern District, New York.
Southern District, okay. One judge said, it's a parody if the judge thinks it's funny, and it is really almost that, can this company called My Other Bag, like My Other Bag is turn it around and it looks like a Louis Vuitton. So parody is really more of a thing that came up. There are, and we'll see it later, copyright defenses that have been imported into the trademark world, and it's kind of an uncomfortable fit because a lot of times because if you're using it in a trademark sense, you want to make money on it. That's the only reason you're doing it, and so you can't say, well, where I'm making a political comment, but I want you to buy a bunch of my T-shirts where I'm making a political comment. It can be like I say, it's an uncomfortable fit. These trademark defenses or these copyright defenses that kind of get imported into the trademark world, which is why you hear a lot of people basically online saying, well, why can't I use this? It's just a lot of it has to do, if you're making commercial use, you've really kind of weakened your ability to say that, oh, this is just for fun, this is just a parody.
The courts don't always agree with that.
The courts don't always agree with that.
There was a case 25 years ago that was one of the first ones out of Texas. And some clever person decided, back when Jordache jeans were basically popular, somebody came out and decided to sell a brand called Lardache, right? Now they thought it was funny, but the people at Jordache didn't think it was funny, and they were making money off of it. And to Mary's point, it was like, oh, it's a joke. It's a parody. I get it. Well, it was a commercial business. It wasn't. And Jordache didn't want people to see that, obviously, and think of Jordache jeans when they saw Lardache jeans. You had a question or a comment? Okay.
Yeah, it's a, like I say, it depends on whether the judge thinks it's funny.
You can always get consent, right? I was just watching a show with Weird Al Yankovic, who does all of the parody stuff.
Right.
He said he always gets consent.
Does he really?
And if they won't give consent, he doesn't.
Well, that's a prudent thing to do. So, it's highly unlikely that the LVMH is going to provide consent on something like this. So.
Well, they gave consent because he's not trying to sell something. I mean, he's being a comedian.
Right, he makes money off of it.
Being a comedian, but not selling a product. So
Yeah, I mean,
Well,
the
he's
song.
selling his records.
Yeah, the song is famous because of the original.
Right.
He's not, and that's again another kind of copyright thing. He's not diminishing the market for the original product.
But he's doing a derivative work that's under
It is.
copyright law.
It would-
And that's
technically
one of
it's a
the things
derivative
under
work.
copyright law is it's a derivative work. And so you got the fair use defense under copyright law, even though they're saying, hey, he's just creating a derivative of what is my work, and that's protected under copyright law. Then you get into the fair use defenses under copyright law, and you bring parity back into it. So it's a really mushy area. And when you get people that want to do that, you almost have to say to them, you better have a litigation budget set up if you want to do X, Y, or Z, because somebody may not think it's terribly funny.
Right. And there's no real guarantee how it's going to turn out. So. Speaking of which, here's copyright, very famous copyrighted mouse who has done a lot to change copyright law, or at least to extend it out. Where are we now? 70 years past?
90.
90 years past the death of the creator, is that it? It just keeps getting longer and longer, and it's because Walt Disney keeps trying to keep, after you've heard of things going into the public domain, once something has been copyrighted and it finally expires and then it goes in the public domain, but copyright law is set by Congress, and Congress can change it, and Congress did to.
It's been extended twice. They've amended the Copyright Act. And since 1976, the 76 Copyright Act, which was 75 years, they've extended it twice now. And the view is that it's for political reasons, lobbying by the Disney company, which basically doesn't want Mickey Mouse, all the original Mickey Mouse cartoons to go into the public domain, which is what they would.
Copyright has to do with content. Okay, works of authorship in a tangible medium. So where trademark is a slogan that identifies goods, copyright has to do with the content on the page or the composition of music. You can that's, if you just think copyright and content, then you'll have a pretty good idea of what it is they're talking about, because people are always talking about copyrighting their trademarks and things like that, and it's a different body of law. There is some, obviously, because it's kind of all in this world, there are some relationships, but so we have author's life to 70. Are we out of date?
That's an old.
That's an old slide. So there you go.
Where'd you pull that from?
I don't know. It's one of these things. So again, it
90.
has now changed twice since we've been doing these lectures.
50 to 70 to
Yeah,
90.
so, yeah, and it's all because of Mickey Mouse, really. I think that was Sonny Bono that did the first one, wasn't it?
Yeah.
When he was in Congress, he, so.
Sponsored the First Amendment because of his connection, obviously.
So, copyright, as Joe was saying, in most countries you don't have to actually register your copyright, and even in the United States, when you create something, it is copyrighted, it is yours. However, in order to sue somebody for copyright infringement, you have to have a copyright registration. You have to go and spend the $35. The interesting thing about copyrights is they're not examined. The Copyright Office doesn't if it's really not a copyrightable material, but they don't go through nearly the falderall that the Trademark Office does. I mean, you get a trademark, somebody has looked at it, and that's why there's actually a presumption when a trademark issues, that you have your presumption of validity. Copyright's not so much. That's why when you go into federal court, you have to prove what it is that you own, which, you have to prove how much has been infringed. So it's kind of like the examination process for a copyright goes on at the back end once it's been infringed, or you think it's been infringed. We've already kind of gone through this, whether trademark, copyright, or patent. They change, and things can have more than one type of protection. So you see the hard roll candy, that there are patents involved in that. There are copyrights and logos, and there are trademarks in the various logos, copyrights in the content of the thing. So you can have a lot of different sorts of protections.
The brand names are trademarks, the artwork is
Work is
copyrightable,
copyrighted, you've
and
got-
the
and then
actual
you've got
candy
the-
that's circular was the subject of a design patent, so.
It gets,
So this is saying someone may be able to oppose one of those, the trademark, patent, and copyright or something.
yeah.
Right.
Right.
You get three,
It's
done. You get three bullets coming at you, and only need to get hit with one of them, you're done.
Okay. There are, I mean, this is, now with music sampling, you really get a lot of issues. That's probably the biggest thing going on in copyright right now. You know, and so a lot of it has, you know, if you know that somebody has just ripped you off, I mean, that's easy, you know. But you have to actually show that this person knew about it. That's the access part, is, you know. And then whether the accused work is substantially similar. And copyright cases can go on forever and have a lot of experts over what is substantially similar or not.
Especially in music.
Yeah, and especially in music, and that's why what this next one is, and maybe you never really thought about this, but the George Harrison was sued for copyright infringement for the My Sweet Lord was his.
He's so fine, the
And-
chiffons.
And the chiffons, He's So Fine. So did you ever really think about the fact that those two kind of sound alike right at the very beginning?
Starts out the same.
The My Sweet Lord, He's So Fine. And so the chiffons sued George Harrison, and he just swore on this, just that he never intended to. I think they finally, they tried to settle it, of course. And then they tried to prove that they weren't similar, but yeah, they were similar. I think they finally, there was not a finding that he was purposely plagiarized it. However, there could have been subconscious plagiarism, because he might have heard that and thought, you know, and he ended up, what, $587 million. So it's probably more than the chiffons made in their entire careers. But
By a factor of $500 million,
but
probably.
anyway, so you know, it's there, and there are actually several of these cases kind of out there, especially in the music world. How much, and like I say, in the sampling, how much have you taken? Have you changed it? Have you made a transformational use of it? It's a real snarl. It's not.
It used to be simple, you know, was it in fact, you know, not functional? Was it original? Was it a work of art? A book, a painting, a motion picture, a photograph? And then you start getting stuff and you start putting that like that on the internet. I don't know if you want to mention that. There's people that contacted us of what they're doing. We've been, you know, there are companies that are out there running basically robots on the internet, looking at every, I will say, knucklehead who's downloading dirty movies and suing them and filing lawsuits in federal court by the hundreds. And we've seen them here. We've had a couple people call us up. We actually just literally had a company who is representing a bunch of motion picture companies who wanted us to be involved in basically going after these people who are mostly, I suspect, young men between the ages of 14 and 35, and filing lawsuits, and they were going to give us a part of whatever we recovered for them. And it was like, oh my God, you know. But the point of it is, it's all copyright infringement, and it's all use of the internet. And there's, you know, people are just back to the point. How smart are people? Well, there are people that are out there doing a lot of stuff and don't realize that everything that they do is getting tracked, and somebody's going to track them down and maybe sue them. And that may be the nicest thing that happens to them.
So.
What about in the age of the internet, as we're speaking, with Instagram and Pinterest as to photos, picking out people's photos?
Same thing. That's
Yeah.
why people put copyright.
But
I'm sorry.
yeah, they put copyright
Embed them.
notices. You'll see a lot of things with big watermarks over the top of them, so that, you know, you just can't clip it and put it down, and, you know, it's useless because it's got this damn watermark all over it, you know.
But to that point, they're out there and they have robots, and artists are really, they've got groups that represent lots of artists, whether they're photographers or people that do pictures, who run robots to see if people are even putting them on their websites. And if it's anything commercial, they will put you over a barrel. I'm just trying to think who that was that wound up paying, well, you know, it's a client, who wound up paying several thousands of dollars because he was going out and hiring what he thought was an independent artist to create some designs, and this clown was basically clipping them off the internet and then selling them to him. And the artist had a law firm that was running a robot over the internet every day, and they found our client using these things and basically demanded several thousands of dollars to avoid getting sued.
I mean, Corbis is, you've heard of Corbis, I mean, if you're ever in a situation where somebody wants you to put something together and you want to put pictures on a presentation, there's a lot of clip art out there. You can find that, and it'll say that it's clip art. If you see something that says Creative Commons, that's something where that is public domain imagery that you can use. But if you want, actually all the good stuff is, you know, something like Corbis images and all that, where you actually have to pay money for it, and you can't just clip something that they own, because again, they're out there looking. That is how they make their money. They make some of their money licensing these images. They make a lot of it in policing it, which, you know, makes sense. It's how do artists get paid if they, you know, people can just steal their work. So, but you have to be careful. That's the big thing. It's be careful, that make sure that if you're using something, an image or something, that it is something that's free for you to use. Just because you can pull it off of Google Images doesn't mean it's free for you to use.
And the worst part of that is that a lot of the Corbis material, and I don't think we've got this in here time to talk about it, but the fact is companies buy from Corbis. They buy the right to use stock photos in commercials and things like that. And it's amazing how many people don't read that agreement, which basically doesn't say that they guarantee you that you have the right to use it free and clear. If you get sued, you know, R.J. Reynolds years ago got sued by a policeman on a horse because they had paid Corbis for stock artwork to use for a print ad for Winston, and he had a picture of a Boston policeman on a horse. Turns out Corbis didn't have the right to the copyright, and that police officer died of lung cancer, and his family saw the ad, and they were really unhappy about it. And a lawsuit ensued, as you might expect. Corbis said, "Did you read the stock art agreement? We're not liable."
Okay, and as you know, we're talking about, there is a fair use defense, and this, again, for the purpose of comment, criticism, news reporting, and of course there is also a parody defense, and it's along the same sorts of lines. Now, we don't actually have the commercial. I don't know how many of you ever saw The Dancing Baby, who, this was the subject of a huge lawsuit. This baby, his mother posted him dancing to some Prince tune that I frankly have never heard of. What was the name of that? Let's Go Crazy. It was Prince, Let's Go Crazy. So Prince sued him, you know, for like this 90-second little, Universal represented Prince, and who owned the copyright, and there was like this, you know, little clip, you've seen them on the internet, it was playing in the background, the kids dancing to it, and you know, so they're suing him for copyright infringement.
By the way, Weird Al Yankovic said the only one who's ever given consent to him is Prince.
Is that right? There you go.
There you go.
Now we know.
And it is his to give. There is the, you know, this, so the YouTube, the safe harbor provisions. Have any of you been ever asked to take down notices under the DMCA? So it says here that the copyright owner must make a subjective good faith determination that the matter complained of is not protected fair use prior to sending a DMCA takedown notice. So they said, look, you know, get a grip. This is, you just can't take everything down. But be careful, or you'll get sued for putting.
Well, that's the Ninth Circuit is really, again, another Ninth Circuit
Yeah.
case. The point of this case is that I think is that what came out of this was you used to write somebody a letter. You thought that they were basically using it. Now they're saying you have to have a good faith belief that their use is not a defense of fair use before you even write them. And if you don't, they can turn around and basically sue you for damages. I think that was the holding of it, which really
tough.
turns the thing on its head. If you're going to be writing somebody, you know, and it's in the Ninth Circuit, which is California, and basically saying you have to do a fair use defense for them, let them, that's their job, you know, they're the other side.
So, yeah, it's you know, you can query whether you know, how far is it that somebody is going too far with trying to protect their rights, and then, you know, swings back the other way. So. Okay, you ready to wrap up?
Do
Okay.
quickly on that, just,
Do you want?
I'll just mention this, just
Okay.
click on it, just do that, just to go through it. Right of
Okay.
publicity, there is such a thing in Ohio, there isn't, it's by state law, 40 other states have right of publicity statutes. It protects persons, their name, their likeness, their persona, everything about them. If you use it in a commercial manner, they can sue you for it, and there have been cases on that for sure. I put John Glenn on there, and actually it was Neil Armstrong's lawyers that got the one in Ohio passed. Whoops, that's wrong. Let's go back there. Basically, that's what it's for. You have people do crowd shots. You use a photograph in your advertising without, and if they're recognizable and you don't get their permission, you're looking at using the right of persona. I think the original case probably came out before there was even a statute,
Now it's up now.
which was Johnny Carson. There was a guy that was a wise guy that thought he was clever, named set up his portable toilet company. Here's Johnny back in the 80s. Johnny Carson didn't think it was terribly funny, filed a lawsuit against him, basically said, hey, you're using my right of publicity, people are going to associate my name with your toilets, and I don't feel like being in the toilets on the side of the road. 2-1 decision upheld Mr. Carson's rights.
Another interesting fact is right of publicity law is state law, and states can have whatever laws they want. Indiana has long rights, post-mortem rights. So
100
that's-
years.
Yeah,
Somebody's
so-
dead 100 years.
Yeah, and so you hear about stars like Elvis and Michael Jackson, all these people making far more money dead than they ever were alive. It's because this one fellow in Indiana has an agency that all he represents is dead celebrities. So you know, that's why photographs of Marilyn Monroe and all that, you can't just assume those are public
Right.
domain, that somebody's
Right.
out there still representing her, and it's a,
Laurel and Hardy and the
appreciative.
Three Stooges. When you see those in advertisements, those people have gotten licenses with the agency out of Indianapolis who represents them. You saw Fred Astaire in an ad a few years ago for Dancing with a Broom. His estate signed a license just because of that. This is only important to wrap up is because 1125. Registration's great. You sue somebody for infringement with a registered trademark under Section 32. This says you can do it under Section 43A, even if it's not registered. Again, you don't have the presumptions of your registration, but you can sue them on the grounds of basically common law trademark infringement. Also, you'll see that it talks about commercial advertising. We're going to wrap up. We don't have time to get into that. 43A of the Lanham Act protects against false advertising. So if you make a false claim in your ad, either about your product or about a competitor's product, where's that one on the show? It's kind of funny. I had to do it. Is it him? Yeah. That's one of the original cases that was in false advertising under 43A of the Lanham Act, which was then Bruce Jenner back in the 70s after he won the Olympic gold medal. A claim for Tropicana, there was a print ad and whatever, and basically he was saying that Tropicana was fresh squeezed orange juice, it was da-da-da-da-da. It was not fresh squeezed orange juice, we all know it was not. And as a result, a competitor sued Tropicana, and it was found that violated Section 43A, or the false advertising section. As Marla said, I think it's probably time to call it a day, and we actually had enough material to keep everybody occupied. Questions, comments? Yes, ma'am.
Is it, I have heard that if you post pictures or anything on Facebook, that becomes property of Facebook, is that true?
No,
No.
no. Which is why a lot of people, you'll see them, they'll put a copyright notice on there, so that if you share it, it's got a copyright notice or a watermark or something on it. Especially authors have gotten to that point. They don't want you doing it, but the answer is no, it is not Facebook's property whatsoever, just because you're using their service any more than it's Instagram. Yes, sir?
Yes, some of this is gonna be on your website or most of it, or?
I don't know. We'll have to talk with Marla about that when we're done.
I'm not sure if the camera picks it up.
Okay.
It'd be nice.
Yeah, if it's on
Yeah,
there.
we'll see if we can.
We'll see what-
put
we'll
the-
talk
maybe
about it.
put some of the PowerPoint on the website.
Okay. Okay,
Thank
sure.
you.